ना मेरे पास अर्निंग का कोई स्रोत है, फिर भी मैं इस जो सर एलिगेशन है, मैं उस जगह में नहीं जाना चाहती दोबारा। जो इंसान मुझे बेइज्जत करके निकाले हैं, अपमानित करके निकाले, मेरी ईमानदारी पर सवाल उठा के निकाले,
Lordships, Miss Saigal initially.
Micus in this matter, my lords. My lords, I must just submit it's an old case, but this honorable court had just asked Director DLSA to assist her during that period of time because she had come from another state, my lord. It was for a limited period of time, my lords. And in fact, her proceedings have also been disposed of now.
सर मैं सिर्फ इतना ही कहना चाहती हूँ कि मेरी ईमानदारी पर सवाल उठाए, पूरी जिंदगी मेरी खराब हो रही है, मैं उस चीज को नहीं मेंशन कर सकती सर। मैं उस जगह भी नहीं दोबारा जाना चाहती जहां से मुझे अपमानित करके, लेकिन मेरे ऊपर जो झूठे एलिगेशन लगाए हैं, आज मेरी भूखे मरने की स्थिति है सर। 1.5 साल से कोई कमाई का जरिया ना होने की वजह से मुझे परेशानी कितनी क्रिएट हो रही है। मेरे अर्निंग के लिए, मुझे पालने के लिए कोई नहीं है सर। मैं या तो मैं सुसाइड कर लूं या तो मैं हेलो सर, मैं हेलो सर, मैं अनलॉक हो गया।
बताइए सुन रहा है, सुनाइए।
मैं या तो सुसाइड कर लूं सर, या तो मैं भीख मांगू, बताइए आप क्या करूं। लेकिन मैं फिर भी उस जगह नहीं जाना चाहती सर, दोबारा नहीं जाना चाहती डीएलएसए में, क्योंकि
दोनों ही काम नहीं कर रहे, दोनों काम करोगे तो आपकी कमजोरी साबित होती है उसमें। हाँ, इसका
नहीं करूंगी सर, मैं मत कर लूंगी सर, लेकिन मैं ना सर, मैं उस जगह दोबारा नहीं जाऊंगी जहां से अपमानित करके, लेकिन मुझे ये झूठा आरोप लगा के अपमानित करके निकाला गया है। तो इसलिए सर मेरा पूरा आप अकाउंट खंगाल लीजिए, कहीं से भी अगर मेरे खिलाफ 1% भी अगर गलत आरोप लगते हैं सर, तो मुझे जो सजा देंगे मैं मंजूर करती हूँ, लेकिन मेरे ऊपर ये गलत आरोप सिर्फ इसलिए लगाए।
7 years experience.
My lord, the Lordship 2014 order where there was I think in 2000.
Page 8 is the first order, your Lordships, and page 13 is the other order. Page 13, your Lordships, she's got appointed.
सर मुझे आज बोलने दीजिए सर, मैं
See page 8. Lordships have directed that various interim orders and for the benefit the petitioner shall continue to enjoy, and those orders will continue to operate despite disposal of this petition.
Where is the order directing the
Initial order where she was directed to be appointed?
2014 or 15. I don't have all the entire file with me right now because it has
the order?
Because yes, my lords, I checked. The orders are only available from 2017 onwards.
In all,
My lords, but she was appointed in the.
there is no dispute about it because your DLSA proceedings are annexed.
My lord.
Refers to a
My lords.
import directive.
My lords.
But in our
My lords,
have been an oral observation of this.
No, my lord, there was an order. I'll try and find it, my lords, because this honorable court had just directed DLSA to assist her
Page
because in
29.
this particular manner,
Page 20.
she had come from another state, from Chhattisgarh, my lords.
Yeah.
2014 order. 14
Page
15 order.
29 is the main.
No, where is the first? Lordships will see page 29.
Madam,
Lordships will see page 29. It says, therefore, we request DLSA to continue to engage Miss M until further orders. And that's
which order? What is the date of the order?
Lordships, that's 24/7/2017 at
Yes,
page
yes, yes.
29. And thereafter, your Lordships, by this order which I've referred at page 8 in 2019.
Continue. 24/2000, there is no order given to me at least.
24/7/2017.
29 of that application.
number
In our IA, your lordships, I'm sorry.
31987.
I see.
There has to be an older order. 15 ka order.
So your lordships, various interim orders were made prior to that, and the final order, your lordships, is at page 8.
Also.
Yes,
if
your
you see
lordship.
Page 18 of the DSLA.
Yes, your
Of
lordships.
28/10/14.
Please, your
Refers to a Supreme Court.
We have heard learned senior.
Yes, your lordships.
We have heard learned senior counsel representing the Delhi State Legal Service Authority, as also Ms. M. Dash learned legal aid counsel. With reference to the prayers contained in MA number 2708 of 2025 and MA number 67151 of 2025. First of, having regard to the fact that, I say, having regard to the continuum, having regard to the uninterrupted services rendered by Ms. M as a legal aid counsel for a long period, the order dated 24th July 2017 is recalled. The last line of the order dated 24th July 2017 is recalled. List of all the subsequent orders are also modified / clarified to the extent that the Delhi State Legal Service Authority shall be at liberty to prepare a first panel of legal aid counsels based upon a transparent, fair, and non-discriminatory criteria founded upon the principle of inclusivity.
Your lordships, this is Legal Services Council for Child Welfare Committee. So this is for the child welfare specific.
All you can
Yes,
put,
very well.
in press panel, including for
Child welfare.
including for
Child welfare committee.
child
Committee.
child welfare committee. The applicant, Ms. M, shall also be at liberty to apply for her fresh empanelment,
Please, your lordship.
and such an application shall be considered as per its own merits without prejudice to
Great.
the ongoing inquiry, and without prejudice to the pending inquiry. Both the MS stand disposed of course.
And your lordships, the proceedings in High Court shall be carried out on merits. She has challenged the inquiry report. So that will have its own effect, your lordships.
The High Court may accordingly proceed to decide. Is on judicial side.
She's filed a writ petition against us. Inquiry.
That you, High Court will decide.
Yes, your lordships.
It goes without saying that the High Court shall be at liberty to have the. Should we say anything about that petition?
Your lordships, uninfluenced by lordship's order, will be also decided on its own merits.
The legal service authority shall be at liberty to request the High Court to decide the pending writ petition expeditiously.
Please. Grateful.
Lordship, this 10, item 10 matter, I have a number of objections against the interim order which has not been considered. But since your lordship had already taken a particular view So therefore, I don't think anything further remains. Only the point that there are three matters. Office report indicates three matters. My case is in SLP Civil 34 of 2026. My case will be disposed of accordingly because it pertains to headquarters. Let's see what they have done. They have made the headquarters 12 to 15 kilometers away from the main.
We are not simply seek to dismiss, we are granted.
Lordship, in 34, that is my case, Lordship. Just want to show this.
Lordship, I am appearing one of the matter, Lordship.
This 34.
Lordship, I am appearing one of the matter, Lordship. The guideline has been treated has been treated as directly, Lordship, not as mandatory.
Lordship?
Lordship,
In this sense, remaining two orders are different, but
Lordship, the objection that has been prescribed under the Act has been treated as directly, not as mandatory, Lordship. That should be considered also. The objection that has been filed has not been treated in a proper manner as per the Act, Lordship.
This is a comprehensive liberty granted already. You can raise all your contention there.
Please, Lordship.
that's correct, Lordship. In 34,
Same order as 5th January 20,
I am grateful.
2026.
Oblige, Lordship. What else?
Level.
What else? Huh? 15?
Yes, please.
My lord, called item 11.
Okay. No, 11.
Please, my lords, this is a matter relating to that Dharamkot elections in Punjab where my lords had appointed a fact-finding commission. My lords, on the day of the filing of the nomination, my lord, it's pending. The related matter of the fact-finding commission is SLP 3838 of 2025. This matter can be connected with that. Yes, my lords. My lords, on the day of the filing of the nomination, we were not given police protection, which was ordered by the High Court.
So, issue notice tag with so and so forth. Can you give the number of SLP which is pending?
Please, my lords.
SLP 3894?
3838 of 2025. SLP civil.
3894.
3838.
3894. Seema Sharma.
My lords, there were certain connected SLPs in that matter. My SLP was 3838. My lords may say 3894. That is also fine.
And just circle.
Grateful, man.
They've changed the sequence again. Sequence, but no. Trapped.
Your Lordship, the issue in this matter is whether the state notification can overrule the parliamentary statute, because the respondent number 8 is the Buddhist minority institution, and we are the petitioner. We want to take the admission in respondent number 8 college. But the issue is that the state of UP is not granting the status of minority, though the National Commission for Minorities Education Institution has granted the minority status to respondent number 8. The concerned SLP is also pending before your Lordship, SLP number 17003, and the interim order was passed in that. But that order is not applicable for this year. So we want that
Your locus standi?
my locus standi is this, because we are the need be the qualified student in this matter, and we want to take the admission in that college, and there is nothing.
How can you make your choice that you want to take admission in that college? It will all depend upon your merit, and the allocation will be done by the committee.
But that matter is also pending in SLP, Your Lordship. That order may please be extended for this year.
SLP will decide.
Because we are the sufferers because of this illegal position of law, we are suffering because of that thing.
Did you apply as minority candidate or a general candidate?
I applied as a Buddhist minority candidate, and that is
Applied as general candidate, sir.
that is Your Lordship. I have
We have applied as general category candidate. Then
Your Lordship, please see the page number 52A.
yes.
It is a form. The category is general, but religion is Buddhism.
That's
So
a
that's a
general
general
category.
candidate. You are not applying as a minority candidate, and the order of the High Court has not been stayed. Only in respect of 2022-23, because the judgment came at that time, and some people had filed applications for the minority seats, presuming because of the National Commission's finding that this institution is a minority, Buddhist minority institution. This court gave that opportunity of being fixed as per the counseling. But when you are applying in 2025-26, you are fully conscious of the judgment of the Allahabad High Court, saying it's not a minority institution. But judgment does not get suspended by this court in the earlier SLP. So why should you get that privilege?
But that one order also.
And who is this candidate at page 52B? His name is Krishna Kumar Punia. He is resident of Satrod Kala. Satrod Kala is a suburban area of Hisar.
52B is also the petitioner number.
So how are you minority?
Minority because I am Buddhist, Your Lordship.
Show your birth certificate.
My certificate is placed at
Show me your birth certificate.
certificate of minority community status. Certificate is page number 50 and 51, Your Lordship.
22-23 judgment was in September 22. So the issue was not settled whether this is a minority institution. That is why for that does not mean that it's going to continue ad infinitum.
That is the Nikhil Kumar Punia is 50 and that Ekta is at 52, 51, sorry.
The minority.
Locus would like to seek this direction. We will decide your main case. No case to issue. And where are the details of the certificate? Where is your birth certificate? of Sat Road Kala.
But your lordship, please give me the next date. I will produce the birth certificate, your lordship. Please entertain the writ petition up to the extent that state notification cannot overrule the parliamentary state.
Please see P6, brother, page 52. Please see P6. We are which Punya? Don't now. I have to ask this blunt question to you in open court.
Yes,
Page 52. Your column number 7. Work category is general.
yes, your
Agada Punyas can be in the scheduled caste category also, or reserve category. Punya can be Jat also, general category. So
Yes.
which Punya you are?
we are that.
You are Jat.
Yeah.
Then how you have become Buddhist?
So, but
Your
we
plain
have,
fraud
we
was-
have converted to Buddhism, your lordship. Anybody can convert to
Wonderful.
Buddhism.
This is another way of fraud. Application outrightly dismissed. Main case will list it. You want to now slash the rights of some genuine bona fide minority candidates also. One of the richest place, one of the best located village, belonging to a upper caste community, having good agriculture land, all facilities in this state. You should be proud of your merit. Instead of taking the rights of those who are really deprived.
Your lordship, we have genuinely taken the Buddhism, we have adopted Buddhism.
This kind of, then everybody will, this all, then upper caste will start adopting.
Examination के पहले Buddhist हुआ.
Because we have taken we have changed to the religion to Buddhism, that's why we are considering ourselves as a Buddhist.
Don't compel us to make further comments.
My lords, I appear in item 13. See, appearing counsel is on appearing online, main counsel. Anupam Kishore Sinha.
Because
May it please your lordship, am I audible? May it please your lordship.
We are at pains to find out how the subdivision officer Isar, so and so, paper with the has issued the certificates. So, say like this. This application has been moved by some candidates purportedly claiming belonging to Buddhist minority community. While going through the report, we found that the minority certificates have been issued by the subdivision officer in brackets civil Hisar the minority certificate of minority community dated 17th February 2025 have been issued by the SDO by the subdivision officer in bracket C civil के लिए Hisar in favor of Nikhil Kumar Punya, son of Krishna Kumar, and Ekta, daughter of Krishna Kumar, both residents of house number 115 from a landmark as block 2, village Sat Road Kala, district Hisar. Next paragraph. The record further reveals that both the candidates have, while applying to the National Board of Examination in Medical Sciences, disclosed themselves as inverted comma general candidates. the form to this effect Annexure P6. And P7 are also on record. On a further inquiry, we have ascertained from counsel for the applicants that the candidates are actually born as general category candidates. And then the candidates are belong to general category by birth. It appears that the issuance of certificates by SDO Civil requires a deeper probe by the higher authorities from especially in light of the fact that while appearing in the NEET-PG 2025 examination, if the candidates appeared as general category candidates and they have further categorically mentioned that they do not belong to economically weaker sections of society, then how have they become minority candidates? How they have become candidates belonging to minority community? Question mark. We would like to know from the Chief Secretary State of Haryana as to what are the guidelines for issuing the minority certificate. 2. Is it permissible that an upper class general category candidate who are above even economically weaker sections and who in 2025 examination itself have disclosed their identity as general category candidates, can be permitted to be converted into Buddhist minority community. Next, if not, what was the basis for the SDO Civil to issue the subject certificates? Next, the further directions will depend upon the status report that is required to be submitted by the state of Haryana within 2 weeks. Meanwhile, then they say the application seeking admission as minority as candidate belonging to minority community is accordingly dismissed. What's the matter on Sansuri? Where did you call it that local single or something? Immediately run away.
My lord's arguing counsel is appearing online.
Decline.
May it please your lordship.
Yes, please.
Your lordship, I would like to apologize that I am not able to appear physically before your lordship. In fact, I had even circulated a letter which was not placed on record. However, I am ready if your lordship will hear me. Your lordship, I am 45 years old woman who is affected by nearly 8 years of delay in disposal of her writ appeal before the Honorable Allahabad High Court. Despite the matter being listed.
It's not like council. Every day now we are getting this kind of petition. Every day. And all these matters, most of the 99% writ petitions only pertain to Allahabad High Court. So what's happening? You want us to now run the day-to-day docket, day-to-day roster, day-to-day listing of the High Court?
Certainly not, Your Lordship. My only predicament is that I have done everything within my powers. I have moved the listing application more than half a dozen times.
Your petition, we understand, your petition of 2018. Which are the
Yes, Your
ones
Lordship.
in that High Court?
Your Lordship, the difficulty is that on the first date the matter gets listed, counter affidavit is to be filed. 1 month is given, counter affidavit is also not filed, Your Lordship. Your Lordship, my professional life will soon come to an end. And ultimately, whatever the Honorable High Court may decide might not be of.
Please tell us what is the fate of those thousands of writ petitioners whose writ petitions are pending there since 1990 and they are unfortunately not in a position to come to the Supreme Court, file a writ petition and secure an order.
Your Lordship, that is certainly an unfortunate, Your Lordship. I completely empathize with those writ petitions. But in my case also it is amounting to denial of access, which Your Lordship have held that amounts to Article 21. Your Lordship may pass a gentle observation that it may be decided in 6 months, Your Lordship.
We know it over the value of our general observation. We will encash that observation immediately.
Your Lordship, the respondent bank has not filed its counter after 8 years, even though it was directed to do so. They are taking advantage of this limitation, Your Lordship. My professional life will come to an end, Your Lordship. Just a little indulgence here would go a long way.
We are not inclined to entertain this petition. The same is accordingly discussed. However, if the bank has not filed any counter affidavit and the pleadings are still incomplete, the petition shall be at liberty to move an appropriate application before the High Court.
Much obliged, Your Lordship.
Liberty aforementioned disposal.
Much obliged.
May I please, Malas? Malas, 2 reports. First report says the MMTC at fault. Second report says inconclusive because there is not sufficiency of evidence. Day 1, on the same day I go to the High Court. I said they are quoting 70%. I am ready to give on day 1 it's 100%. Admittedly, there is a fault on the part of MMTC.
You see, the point is that there is this story of technical glitch that has been disbelieved.
So that's not been disbelieved. It is not found. What they say is the first report is conclusive.
It is not proved.
So yes, so assuming for a minute, Malas, today the difference comes out to around 5,000 crores, Malas. And I've stated so before the High Court. All I'm saying, and there are only 2 bidders. It's not there are multiple bidders. And it's an exercise of 2 hours. It's not even that you have to restart everything in the beginning itself. So today, looking at the position that the High Court, the petition was pending for 7 months, Malas. And it's conducting the auction is 2 hours process. The 2 bidders which are there, it is admitted position. If we see the video, I can understand there is half screen visible, not visible. The distress in the voice on the same time the call is made to the concerned officer. The call is also there on the video itself. Now I can understand, Malas, if it's been out and out, somebody trying to intervene in it, it is a matter of few minutes. And all I'm saying is that if it is 2 hours process, it is not that the whole process is to be restarted. And I have on the day 1 to say my bona fide, I said I'm willing to make 100% because the other has quoted 70%. And if we look at, and it's only at the prospecting stage, I can understand if the rights are allocated to somebody, like in other cases of mining or coal mine. These are prospecting licenses. And after prospecting means the exploration, and it is to be done after 3 years. If something is found, then the lease agreement is to be entered into, Malas. To non-suit me on this ground, and I'm a serious player. I have already running the phosphate mines. It's not that something which has been tried to make out a case. And High Court is not disagreeing with me. High Court is saying between the first report, the MMTC has gone and directly got in touch with the committee, provided certain information. Second report says it's not conclusive. I can understand this is precisely the article.
What is the last bid accepted by them?
70.2, Malas. 70. So how it works, Malas, when they bid, the requirement is that whatever the potentially extracted materials value, what percentage do you bid? Assuming the total extracted value is 100, they 70% will give it to you. I'm saying I'm willing to give 100% because I process that material. I get the material and add value to that material. If they may be trading or what, that I'm not in my business. But I'm saying on the day one, first day on 27th of July, the outcome is there. I go on the same day before the court. I say I'm willing to give 100%. And if the material is actually found, the differential value comes out to around 5,000 crores. I stated so before the High Court. And it's all I'm saying, I may not succeed, and it's a fraction of difference which has been made. It's not that I made an attempt. Phone calls are there, WhatsApp messages there on that day.
Can I just say this? Milord,
Mr. Shankar, I'm not finished yet. Please just give me a minute.
this 100% is a real bogey.
I'm grateful. I'll show something very interesting.
Milord, can I just explain, Milord, your lordships, the first impression is the first report, the second report. There are a couple of things missing. A learned friend says 100%. Every time I will show the bidding history, he was increasing his bid by 0.05.
That's a requirement of regulation.
If you don't mind now.
That's a requirement of regulation.
Mr. Balbir, if you don't mind.
I'm sorry.
I was increasing my bid by 0.50. If he wanted to give 100%, he could have given it at any stage, Milord. He was watching and increasing it by a minuscule amount. 1. 2, Milord, this report, because there was a first preliminary report, Milord, he was bidding from the desktop. Now, Milord, there is a 2-step authentication process, Milord. You go to a hotel, they say give you a mobile number, they give you an OTP, you come back. If you do not put in the right OTP, I'm just giving you one of the methods, Milord, you will not connect. Now, the report of the expert, Milord, says there is no problem with my server in the sense the platform. There are 10 auctions going on at the same time. 250 bidders, Milord.
5 kbp.
Even at 5, no.
5 kbp, you are having 20 bids.
No, Milord.
Although we understand your second expert report says that it's not because of the bandwidth, but if you see the first report and the second report, there was no server log with regard. There is no server log, and that is why they say that there is a possibility of an error on the server side. Now that is slightly watered down in the second report because the screenshot of his effort for logging in is there, and they say that the entire screen picture is not there. It shows the cursor moving up,
yes,
but it's not clear whether it was moving up to click on the error window or it was a blank window as Mr. Singh would like us to believe. In these sort of a very, I would say ambivalent status on expert opinion, it's better to give all favor of public interest, isn't it?
Can I
respond to that public interest, the revenue? Only are in favor of public interest.
Would your lordship just see one thing? At page 360, what did they say, my lord? Exactly. My lord, why is it when he was bidding through a desktop, my lord, his logs are not available?
Point number why is MMTC taking this position to say not willing to accept the more revenue, something coming in the position being taken? I'm a little surprised of that part.
Lord, I don't understand.
And people have voted, people have given a price more than 100%.
Lord, I am for MSTC. I have not stated anything of that nature. I am, Lord, the union can decide. In fact, the High Court had asked the union. Lord, my learned friend should not make an unfair statement. MSTC is only looking after the platform, nothing beyond it. No. And Lord, I am only correcting one thing which factually your lordships have noted, that the report says he has not provided the main desktop why he got out.
Desktop does not really disqualify Mr. Singh's client because he was making the second attempt within the 8-minute slot.
Absolutely.
So let us say in the first desktop effort,
that's right,
it was his fault not to connect. Yeah. He had a right to connect within 8 minutes.
That's your lordship is absolutely
right. The second attempt by the second device.
Yes.
So reason best known to him, he shifted off to a second device.
Fair enough, lordships are right.
Second
8 minutes
device,
were available.
No clear picture emerging. As to what,
There I want to clarify one thing. Lordships are right.
The way, if you don't mind, just give me 1 minute. I just want to respond to.
But I just want MSTC, something should not.
Just look at 60. Lord, I'll tell my lords, it seems, my lord, at first glance, my lord, your lordships are right. You look at.
Well, we can do the inter-C bidding between
Absolutely, well, the
Lord, can I,
and ultimately the benefit to the public. What the
I am very old at it as companies that have been doing it.
Lord, I know.
Well, then, what I have said is that these are natural resources
Lord,
to people who country, whatever the maximum comes, and it's not. There's only two.
It's
I can understand.
Our purpose in a public law domain
Yes, ma'am.
is not only to see the contractual rights being preserved, but also to see when there is some ambivalence and elbow space to ensure public interest. And here a higher rate, if fixed within the parameters of the contractual fidelity, we will try to explore that. That's
The lordships are right, my lord. I cannot, but no one can quibble with this if you can get a higher rate. Now, when you test the bona fides of the person coming to court, what would your lordship see? The history. Please see page 179, my lord. The history at the way he was bidding. Please see what is
It was conducted by MSTC.
Yes.
The platform was being maintained by MSTC. The beneficiary of the mining, of course, is the government. That's why I clarified, we are only to answer your lordships and assist.
Who is representing the government?
That's, representation of High Court, somebody had appeared. At the moment, this is a fresh matter. In fact, we have also not filed caveat. I was instructed today morning just to limit my submissions only if there is anything with the platform which your lordships need. Nothing further. That's why I clarified.
Lord, would your lordship just see page 179? Please test the bona fides. Justice Bachi and my lord Chief Justice would look at page 179. How was he bidding? He says 100%. What stopped him from 100%, Lord?
Issue notice when Mr. Shabda, Assistant Counsel, you are accept notice on behalf of respondent 3. Mr. Dave, Assistant Counsel, accept notice on behalf of respondent 2. That Union of India reserved through the Office of the Attorney General for India and Solicitor of India. Alternable next Wednesday. Meanwhile, you can have instructions. There are two ways. In all fairness, a short notice should go in the, on a public platform, whether it's on website or a newspaper or maybe whatever, that the court is inclined to go for inter-C bidding, and then maybe that a third player comes and he might offer better. We don't mind that also.
nobody applied.
Absolutely.
You, both of you, we can compete.
I have just one
submission is this, my lord. Unless your lordships find there is some malafide, your lordships have never interfered.
But wait, it's not a question of malafide. It's a question of his fairly accessing the bidding process.
Right.
Now, that clarity is not there, that it was his failure which had intervened or interfered with his access to the bidding process.
Yes, my lord.
Then why won't we, as we said, some elbow space remaining, some doubt remaining, explore the idea of getting more value for public goods? That's simple. I don't think MSTC would have any
Union, my lord,
difficulty on it.
it's better your union says that's exact, and that is exactly what your lordships will intend to.
My lord, when your lordships form this view, your lordship will also look at the way he has proceeded. Now, this was a judgment of 16th December. When has he filed an SLP? On 6th January, keeps it in defect, and then takes it out and gets it listed on, my lord, clears the defects on 15th January.
There is one
If someone is in hurry,
One concern, my lord, since I want to be fair, my lord, this capturing of the screen halfway, because the error comes only at the top. So there is something why it's not explained. To be fair, there may be a reason. But I kept telling the Honorable High Court also that why, if you are capturing the whole thing, because one is, of course, your lordship rightly said he had that 8 minutes. But the reason, because my lord, I had almost hundreds of at the same time. So what we did, we reinvestigated. At the very same time of that 10 minutes, there were repeated bids which went through absolutely
Correct.
smooth.
That's why the bandwidth has not been considered
course.
to be a hindrance. Because there were, if we are not wrong, 6 bids were made apart from him and other bids went through.
Hundreds of bid at the very same time. So only one a person has a problem and the clause says that he will be responsible. My only concern is that the platform sanctity then comes into issue. That is what your lordship may protect in whatever manner, because it should not be that one person who is not giving any reason why he captures only a half portion of the screen.
We are highlighting the second reason more than the technical issue.
Yes.
That we are highlighting the
That's right.
interest.
That's right.
My lord, that's where, my lord, we come in, my lord. If the person says, I actually, my lord, which is why I started by saying it's a bogey. If the person says, I'm willing to go to 100%, what stopped him from doing and not doing it at
That's commercial wisdom. Why will we go for 100% when you are going at 70?
Therefore, my lord, for him to turn around and say
bid
that
condition
this is
provided that in 8
4,000
minutes,
crore loss is a complete bogey.
In fact, that money should be deposited by both.
Yes.
They should deposit that 4,000 claim which is made, and your lordship should start from there so that the revenue gets, my lord, accounted for. If that statement is made on oath, it must be, my lord, honored.
Willing to go at 100%.
whatever the outcome.
Let's see, let's test his bona fides.
The union will be happy with 4,000 crores.
Then direct him. Deposits at 100%.
Great. Well, all instructions accordingly.
Very well.
We will take up.
Grateful.
Grateful. Wait, please.
Your lordships, then do we need to file a counter in this?
Who's fixed, lordships?
My lord, your lordship may still delve over it, my lord, and I don't think this is a matter where your lordships have first impressions. Please hear us a little bit more. Maybe your lordships will come to a different conclusion. Despite this overwhelming, my lord, the submission made that there is a loss of public interest, my lord, I'll show that this person who gives you a video, he captures, he has the good sense to put it on video, but he doesn't capture the whole screen. Why? He doesn't give the logs of the desktop. Why? Lord, those are things that your lordship would give us an opportunity. And then he comes after, Lord, 16 December is the judgment and there is a delay.
Very such a fatal delay. 15 December winter break.
No, Lord, when your lordships connect the dot.
The very opening the petition was filed, SLP was filed.
My lord, yes, it was filed. Then you keep it for in defects for 10 days, my lord. Don't get it listed.
Yes, sir.
You don't remove the objections. My lord, I am only saying that if your lordships are considering on Wednesday, please hear us a little bit more and then form a view one way or the other, my lord. Whether it needs to go for a rebidding. Give us that opening and opportunity, my lord.
The revenue part is the paramount consideration. That once we know it, well, that the things have not really settled, the parties have not taken the advantage of their position, and the processes at the preliminary stage, and there will be a huge loss to the revenue. That I think.
So your lordships go by the preponderance test, my lord. Your lordship sitting in another combination have said when experts rule, there's not one, then we don't normally interfere. Now, what can a court do in a situation when he doesn't give you the data? He doesn't give you the logs. Why doesn't he give the logs of the desktop, my lord? That's a question. That's a red flag. Why doesn't he give you a video of the entire screen?
We can give this much discount to you that if you come to equivalent to his offer, then we can allow you to sustain. Yes. That's what.
You have the right of first refusal. First.
But your lordships would also, whatever, my lord, on Wednesday.
Because that takes care of our.
My lord, your lordship would also test this submission made that I am going to bid at 100%. That needs to be tested.
No, that is not unusual. It's not. It doesn't happen regularly or invariably, but it also there are instances where.
No, Chief Justice is right, my lord, but this he can't just sort of float an idea and not back it up, my lord. That's my concern. If he says 100%, he should come with a 100% bid.
Well, we should secure. That will have to secure the whatever the bank guarantee, the fixed deposit, or will have to secure the interest of this union.
You come next, you take the matter.
Next Wednesday we'll hear.
Yes.
Yes, item.
Yes, may it please, Lord. The two sets of followers of Ramanuja, Vaishnavites, we are the Vadakalais. The learned single judge had worked out an equitable order where both could decide this. And what we want is that our Guru, Vedanta Resikas, blessings also should be invoked. And now what the Tengalais say is, only Manavara Mamunigal, who is the greater Guru, he should be invoked, and we should be completely kept out. In a Vadakalai temple, it is a denominational temple which is being run by us. All the Namam, everything is of Vadakalai. We are kept out in regard to recitation of this. This is
Civil suit.
Lord,
and both can.
Yes.
Both can.
we'll try it. Lord, one more thing, Your Lordship, we'll try to settle it. So the other thing now, Lord, in this kind of thing, Your Lordship's judgment in that citizenship becomes very important on fraternity. Lordship has put the preamble fraternity on a high pedestal. Now we are two groups. We are not asking that we get exclusive right. We are saying before the Prabandham start, you say first, we'll 10 seconds, we'll say second, that's all. We are not saying that we want priority. So now Lordship has put fraternity in from paragraph, that also has to be considered by the courts, my Lord. How can all people coexist together? It's not antithetical to them. We are not defiling the Garbhagraham at all. We just want to say two, because I believe in this particular sect, you attain moksha only through your Guru. So unless you say some few words to the Guru, that's a strong belief which we have, Lord. That may not be in Maharashtra, may not be here. But that belief is there for 750 years. And Lord, a single judge said that they decide first, we decide later. It takes 20 seconds, and then the 25 seconds, my friend appears. And then the main prayer starts. That went on for more than 2 years throughout the COVID.
No. Peacefully.
Then now the executive said that only one person can do. If the other person does, it will not be banned. Who's the executive officer to say? That's how the writ petition came.
We amicably resolve this.
We'll try it, Lord.
My Lord, can I just say one thing? 1715, there was an agreement. There have been judgments 1882, 1915, 1939, and a Privy Council rejecting the certificate against the judgment of 1915. All of them said one thing. The temple's recitation of the mantra. The mantram is this mantram, which was the old Telagalai mantram, as they say. This was the mantram. That's been going on for 300 years. The Vadagalai say, no, the temple should recite another mantram.
Mantram is being recited anywhere.
And then what they did, what really created the problem, my Lord, for the 1935 judgment, is they used to come, push everybody aside, and when the mantram being recited, they would come in the front and overcome the proceedings, and then they would recite their mantrams. That is why the 1950 induction order was given.
Mr. Sundaram, all these apprehensions or whatever the past unfortunate incidents have happened, those can be taken care. We are only requesting both sides, please go for some kind of a mediation.
Once your lordship's mediation, my answer is yes. I always say yes.
DT, at least before DT, we don't want. All of you are there, Natmastak before there. Why this, this dispute should not acquire a nature of a dispute between two languages.
Can I?
That is our
adversary.
I fully, my lord, can I just give one example?
Both are such a beautiful languages of this country, such a wonderful heritage this country feel proud of it. And you are of the Tamil Nadu is one of the states where this entire heritage is so well maintained. Everybody feels so happy. And you are the showcase of the culture of the Indian culture there. On this issue,
in fact,
the Kanchipuram.
My lord, what's falling from my lord, I fully understand. If it's a language issue, whatever. I'll just put it in a nutshell. My lord, I go forward and I say in Tirupati, Tirumala, don't do the Suprabhatam Instead, do the Lalita Sahasnama.
No,
One is not better than the other. It is a ritual. What I am suggesting is this. Privately, whatever is recited, every person has a right to recite what they want. But what they are saying is the temple should recite something else. That is the problem.
the temple is a
Correct, but there's one. They are saying, say Suprabhatam, say.
If your lordship feels,
Two verses from your side.
my lords, it's fallen from my lords, go for mediation.
Yes, we'll go for mediation.
My lords, we will go for mediation. Your lordship will consider. I was just thinking, my lord, your lordship would nominate somebody who will be capable of mediating a subject like this.
आप अपने इष्ट देवताओं को एक की बजाय दो प्रार्थना करते हैं, 2 बार पूजा करते हैं, तो इसमें देवता नाराज होंगे, खुश होंगे, प्रसन्न होंगे.
There are other temples.
That solves the problem.
One aspect, my lord, what fell from my
No
lord.
other aspect, Guru Krishna Kumar. The only aspect is that a devotee wants to go with and just bow before the.
No problem. So that we are agreeable.
They cite their own where they will.
No problem. That also we are agreeable. That's not a ritual, my lord. I'm sorry. This is where it's being misstated.
Your mantra in the language you like.
It's all in the same language.
The same language.
It's in the same language.
Language is the same.
No,
Language is the same.
the problem is they are objecting because we recite more or
The first prayer can be by you. The second can be.
We agree,
Both are your Ramanus followers.
My lord, can I?
Look at the saint who has what.
My lord, can I answer, my lord?
Understood.
It's not a linguistic issue at all.
Lord, we'll go for
The
mediation.
language is the same. The temple does a puja where they have a ritual. The temple's ritual, which has been going on for 300 years, they say change the slokas of that ritual. That is where the problem is.
You're undertaking.
That is where the problem is.
In their rituals, they should be free to use their sloka.
No,
In your prayer, you should be free to use your sloka.
Insofar as their ritual
The temple should be free to use the slokas which the temple prayers have used for 300 years.
insofar as
Either side can insist that the temple's ritual should be changed. That's the point.
Actually, Sundaram, even the 1915 Madras High Court judgment upheld in the Privy Council gives them right to give offerings and make their prayers.
No problem. We are agreeable. But not, my lord, we are agreeable.
Therefore, I don't know why mediation is.
My lord, I think I'm being misunderstood. My lord, I don't feel I'm expressing myself properly. Let me try once in a very short way. Your lordship saw what the 1915 judgment, as your lordship say. We are happy with that. We have no issues. We are willing to follow it. What is happening is the 1915 judgment said the temple ritual is this. The temple ritual will be continued as it is. However, they are free to offer whatever rituals they want to offer after that. There is no problem. Their case is the temple ritual should be changed.
No, my lord.
The slokas in the temple.
Let it be made clear the 1915 judgment you have to both.
Please make clear both sides will follow the 1915 judgment.
We do not know why you are imagining a dispute which is actually not there.
Lord, we'll go for mediation.
My lord, your lordship will say we'll follow the 1915 judgment. We are happy.
No, we are not on the right now judgment. We are only on right now. We are on a workable solution. We don't want both the sects of the same great Ramanu's followers. They should fight in courts. That's not the way, and that's not the way that we can appease our deities. Also, that says there you have to completely surrender and surrender yourself.
Because I just wanted to make one thing clear. My Lord Justice Bagchi, I just wanted to make one thing clear. In case we are understood to be saying that we don't want to do what the 15 or what the 15 judgment said, that's not so. We are willing to abide 100% with the 1915 judgment. We are willing to abide by it 100%. And that has been followed till today. Suddenly, my Lord's learned civil judge says, change the system.
Any name both sides will suggest.
What about Justice Ramasubramaniam? He'll be familiar with
That's fine.
Justice Ramasubramaniam might be familiar, my lord, because he's from that here.
What about Justice Ramasubramaniam?
Yes. No, will we keep somebody who's not Justice
Just
Kaul or Justice Lalit?
No, they will not understand. They will not understand. Understand it. They should understand.
No, Justice Kaul.
This Ram Subramanian has an understanding of lot of the temple and the rituals.
Such that
He's justice.
somebody who will keep somebody away from Tamil Nadu.
Therefore, Justice Ram Subramanian would do it.
I can contribute here a bit. Justice Ramasubramaniam is what we call Ayers, like I am. The Ramanuja are the Vaishnavites, Iyengars. So Justice Ramsubrahmanyam will have no interest in either side because he is a follower of Adi Shankara, like me.
He has heard the matter.
And they are followers of Ramanujacharya.
He's just,
So there won't be any
no problem.
Ramanuja was a follower of Adi Shankara.
originally. But then he changed the Vishishta.
The follower of Shankara.
Then he made it Vishishta Advaita instead of Advaita. That was the.
Advaita,
Yes.
Advaita.
Advaita was Madhavacharya.
No, became Dvaitam. Some matter.
That is that is Madhavachari. Madhavachari made it Advaita. Yes.
Advaita.
Well, Justice Ramsubrahmanyam would be the ideal person then.
Justice Kaul or Justice Lalit?
Perhaps they won't, my lord, because this is.
Well, and Justice.
Yes, but he also Chief Justice of Madras High Court.
He was a court.
I had only one submission to make, my lords. The nature of the issue is such that it is appropriate that somebody who is familiar with it will be able to handle it.
I have a suggestion we can solve. My lord, let it be Justice Kaul, assisted by Justice Ramasubramaniam. I'll explain why. Because for these nuances, what comes from the temples there, it might be because Justice Ramasubramaniam will be aware of this. If I'm not mistaken, he was also a philosopher.
I don't want to name any names. It's really.
There only one small
better.
because Justice Ramasubramaniam is the whole time chairperson of the National Human Rights Commission. We are not sure about that whether
I see.
it's permissible and would he like to or not. But what we can do is, if Justice Sanjay Kishan Kaul is a former judge of this court, he has been Chief Justice there.
I will be.
He has been a former Chief Justice.
So associate two persons. We will request Justice Kaul to associate two persons of his choice.
His choice.
Yes.
Who are well conversant about the Tamil culture, about Tamil language, and about everything.
Excellent.
Yes, my lord. Certainly. Certainly, yes.
Grateful.
Certainly, yes.
The
My lord, in the meantime, let the status quo as on today not be disturbed in any way.
We don't want the page 102. Police help being taken, etc. That means
No, my lord.
if we even go to.
My lord, let the status quo as on today not be disturbed. They went to court seeking a change in the status quo, refused by the court.
They are assaulting us, my lord, in the singing.
We had the problem of personal assault by this, and you had to file an FIR. FIR had to be filed against them.
My lord, for sending it for mediation.
They refused.
Current status quo continued during mediation. Of course, the mediators give any suggestion what is to be done in future, it can be done.
two sets, in bracket 1I, Bengal I, and 2I, Vadakal I.
See, one set is follow Vedanta Desikar.
Are they followers of Sri Ramanujacharya, comma, are the parties to this dispute we are in dispute with respect to the method and manner of making prayers at Sri Vaishnav temples in Tamil Nadu, including Arulamigu Vardaraja Swami Temple at Kanchipuram. During the course of preliminary hearing, we have impressed upon and legislative counsel for the parties have gracefully agreed to explore mediation so that the day-to-day the rituals can be performed in an amicable manner. In this regard, we request Honorable Mr. Justice A. Cole, former judge of this court, who has been Chief Justice of the Madras High Court, to act as the principal mediator. Justice Cole may associate two persons of each choice who are well conversant with Tamil and Sanskrit language, rituals, and the religious history of Tamil Nadu. Next problem. Both sides have agreed to approach Justice Cole along with a copy of this order today itself, or say by tomorrow.
By tomorrow.
By tomorrow. Next program. We request Justice Cole to accept this responsibility of delicate nature we also request Justice Cole to fix his own honorarium and that of his two associates, in addition to the secretarial assistance that may be required by him. After 3-4 weeks?
After 4 weeks. 4 weeks would be best.
Post the matter after 4 weeks. On so date. On so date.
4 weeks, but then I think Holi is coming, so immediately after Holi would be best. I think Holi is there in the last week of.
Post the matter, don't say 4 weeks, we can say post the matter on we can list it either on 9th March or 13th March.
Your Lordships, whatever is convenient. Your
Whenever my lord's concerned.
On 13th.
But Lordship may also say, suppose we are able to reach a settlement, liberty to mention the matter. So
that always is there. We can both.
The party shall be at liberty to make a mention as in any intervention by this court is required.
My lords.
Very well.
Lordship.
We can
actually this is the perhaps
foresee only one thing, that this matter will be amicably resolved only with the intervention of Vaidyanathan Sahab, Datar Sahab and Mr. Sundaram and
We'll do all this. We will certainly do.
We'll do our best, my lord.
If you are true followers of Ramanujan, we will not fight.
My lord, I think I'm the most neutral person.
Same here, my lord.
being an
Pune, so I would not.
Both sides are.
I don't think Mr. Vaidyanathan has.
Interestingly, both of us are smart class.
Smart class.
We are not Vaishnavites.
The strange thing in this case is all the arguing counsel are smart. They are not Vaishnavites.
Of course,
Both the warring groups have landed in the safest hands. Therefore, we are hopeful that.
grateful.
My lords.
Only one person knows, I am that example.
Yes.
This is the Vadakali temple. Where this is also adorning one of the.
His idol is there.
No, we can't chant anything in favor of a deity in the temple. This is unprecedented.
That may be that may not be correct. What is being submitted is not correct.
I think Satish should refrain himself just now.
Information you will share with Justice Cole. That's not.
That can't.
No, that's not correct. What is being.
Chant and be bonus is the order.
No, in case some project
Should not be.
will come to lordship.
Neither side should create any law and order situation.
Persuade Justice Cole to accompany you
I know.
Take him to Kanchipuram.
Would be the best thing.
This,
No, my lord, what my
Absolutely.
friend
Restore
said
not
is
the-
there should be no police inside the temple. That will be very unpleasant.
No, that land. Look, now we are going to justice call. Let's all try to sort this out once and for all.
We follow this action, Manoj. If we
No, in fact, they cannot change rituals.
They should.
Cannot change rituals. In fact, very frankly, my lords,
Thank you.
for both sides, the best thing will be a final solution, because please see the number of litigations that have been in the last 120 years. There have been so many suits, so many representative suits, so much litigation.
Round five.
We'll be very happy if both of us can finally sort it out
In
now.
fact,
We'll
Justice
face it.
Kunshi and Justice Mohan, led in the Namam in regard to the elephant, led passed an equitable order where two elephants can be there sporting two different kinds of Namam.
That had no, that is not a question.
Kind of order that should
That's not a ritual. Anyway, that's not a ritual. We'll face everything before justice call.
Our side, my lord, we have the namam which is a U. Their namam goes up to the nose. Why? So the question was, what will the elephant wear? So one thing was 3 days Y, 3 days U, Sunday rest. Other thing was one elephant will be Y, one elephant will be U.
So
We agreed that your Y elephant can go first, or U elephant can go later.
In fact, 11 judges observed is exactly what is out here also. They can strange thing is, but the problem arose out of the offspring of the elephant. It may be the U or the Y.
Maybe your lordships also should come to the temple once.
Great. Anyway, we'll follow this up.
I think you take to Justice Cole there. And he loves Tamil Nadu, I can say.
Yes.
This much I can tell. He has been my Chief Justice also. He loves Tamil Nadu. But therefore, if you will persuade him,
Yeah, sure.
there will be a solution.
Deeply.
Great.
Plus here today, all I want is that the judgment may be pronounced. It's a habeas corpus, and 13th of November, it was reserved. On 7th occasion, it was heard. May is the detention. Now, maximum period is 1 year of detention. More than 8 months already. And 7 occasions, I got heard it. And Lordship may see on 13th.
All right.
And your Lordships are considering it, that Jharkhand matter. My Lords are considering it.
That's a different issue. Because the petitioner has challenged his preventive detention before the High Court of Jammu, Kashmir and Ladakh. Has challenged the order dated 22nd May 25 of his preventive detention before the High Court of So-and-so to habeas corpus petition number 85 of 2025. As per the government's head in this petition, the above stated habeas corpus petition was finally heard by the Honorable Judge on 13th November 2025. The judgment is still awaited. That's problem. While we see no reason to entertain a writ petition like this, having regard to the nature of relief sought by the petitioner, we request the Honorable Judge to pronounce the judgment expeditiously. There is sufficient to mention.
Lordship, all I am requesting, Lordship, tag it with that main that Jharkhand one writ petition 169 and in the meantime, Lordship, seek a report. Otherwise, do it, there's no harm because earlier my lords are doing it.
Disposed of. You go and show this order, you get the judgment. What's the sitting, Judge?
Lord, I came to this court
Lord, I had come to this court initially in a writ petition because the learned acting Chief Justice, Lord, had passed strictures against me 4 times. Without hearing me, and in all 4 cases, Lord, where I had, in respect of POSCO of offenders, pulled up the police that you are not doing your job properly. They clearly violated, Lord, the POSCO laws. all four occasions, your lordships will not set aside those strictures, and that is why I came here, because I knew I couldn't have gone there. Now, please see three things, my lord. I am being asked to report to a junior officer, number one. My pay is reduced because if I'm not a principal district judge, then your lordships and the all India judges have not kept a different pay band for different levels. So particular allowance which I will not get because of that, so I'll get a lower allowance. And I'm not lastly,
No,
when I retire,
no, what is that allowance, Mr. Vikas Singh?
so there is not an allowance which is being given under the All India Judges Lot case. I've got that notification. It's a special allowance which goes to a principal district judge. To any other judge, it is half the allowance. So it is 7,000. In this case, it is 3,500. So there is a loss of pay also. Lastly, Lord, the most important thing that after retirement, Lord, I've got 7-8 months to retire. After retirement, I will retire as a labor judge, not as even as a principal district judge for all my life. Today, Lord, because ultimately, Lord, that is the rank that I'll be holding. And today, Lord, I am today in the seniority list effectively 7. 2 are not likely to be considered for High Court judgeship for various reasons. So technically, I am also eligible for being considered for High Court judgeship, Lord, in the 5 vacancies which are there in the state for promotee officers. So to face all this humiliation, is Lord, the officer is also present here in court, Lord. I would beseech your Lordship, Lord, that this is not the right way to deal with him. To post him to a position, Lord,
It's in class. Problem is that how long we interfere in the High Court functioning. You see, last time his prayer was that he was posted as full-fledged district judge. He didn't want to go there because he didn't want to go because of the health reasons.
That reason is
his prayer was that he should be posted in.
That is what your Lordship very kind, Lord, took a very compassionate view.
If we clarify, suppose 2-3 things. One, that whatever allowances he is getting as principal district judge, all those allowances will continue to be admissible to him. Number one. Number two, he will not report to any junior judge.
I think then that should suffice.
Except he will directly report to the administrative judge of
that. I think that should suffice. Basically, it's a matter of honor for him, Lord. If Lord should do that, Lord, I don't think there should be any problem.
Hypersensitive judge.
Lordship, I appear for the High Court.
High Court. Madam, these two things, please don't oppose that.
No, yes.
Labor tribunal judge doesn't report to the district judge.
Yes, but Lordship, I
administratively.
Administrative judge.
No, your Lordship, if your Lordship.
We are saying High Court judge. High Court will be the administrative judge.
Most fair.
Yes.
Most fair.
That has to be, because he can't report, he can't be asked to report to a junior judge. Say, this is, fresh petition.
No, there is an IA not in the same matter.
Say, issue notice, IMA, then Madam accepts notice on behalf of the High Court. So, her Shri Vikas Singh and senior counsel on behalf of the applicant petitioner, and Madam on behalf of the High Court. Last paragraph. Pursuant to the observations made in our order dated 19th December 2025, the High Court has posted the petitioner as presiding officer of Labour Court number 1,
I think this is better.
Jaipur Metropolitan Roman capital 2. This must be industrial tribunal also.
Yes.
Come industrial tribunal, because all labor courts are industrial tribunals.
Not only one small suggestion, Lord, if the High Court is also here. Principal district judge town, which is next to Jaipur, is also vacant.
No, but that cannot be. I have instructed.
No, that is lying vacant.
He cannot actually choose a posting.
No, I'm not choosing anything.
No, he is only suggesting that in case you,
Suggesting.
the petitioner has some apprehensions with respect to his rank, status and stature as a principal district judge. We therefore deem it appropriate to clarify and direct as follows. 1. The substantive rank of the petitioner shall continue to be that of principal district judge. 2I, the petitioner shall be entitled to all the allowances payable, admissible to a principal district judge, even while, even during his posting as presiding officer of the Labour Court cum Industrial Tribunal. 3I, the petitioner shall not report to any junior and or a district judge. He shall directly, his administrative control shall directly be with the administrative stroke portfolio judge of the Sessions Division within which the Labour Court cum Industrial Tribunal, within which the present within which the Labour Court cum Industrial Tribunal where the petitioner has been posted, is located. I think that takes care of.
Yes.
So we may place it on record that the Counsel for the High Court has gracefully accepted the suggestions to direction.
Deeply obliged.
Obliged.
My lordship, we have received the refund. No, sir. We just want to tell them that we have received it. It will not. It's mine. My lordship, we have received the refund.
Some time so to be extended. How much time do you want?
No, sir, we have already received the refund.
Received it only gap water. So delay in submission of the money received. Receipt of the amount
Yes.
is conduct.
It is, because the Honorable Judge has expressed his inability actually to accept the appointment and only requests to appoint someone else in his stead.
That's right, bro.
Grateful.
आपका आइटम है
55.
25. No, please, madam. No, please, madam.
Sir, Mr. Raju, but see, yeah.
18 to call out to
18 or 19. They said, sir, now they've again put 18 on the point.
18 to हो गया.
He just said 18.
I think he thought that it's over. I think he went. Oh, no, I mean,
There is some confusion.
I think the law was here because he thought that his matter is over. I think he left because of.
I mean, matter is of course over. Former judge has declined to be the arbitrator, so we are only thinking of appointing someone else.
वो हमारी इंटरिम बेल वही कर रहे हैं उसके बाद उसी बेसिस में लखनऊ में लेंगे उसी बेसिस में लखनऊ को लेंगे उसी बेसिस पे प्लीज मतलब 19 other batch your lordships have the charter handed last time. I have another one, this new one, my lords. Your lordships may kindly have that. No, that is just a chart of what the position is of various accused persons. Of the first is 19, I have listed all the accused and the period that they were in custody, my lords, before your lordships were pleased to grant them interim relief and release them on interim relief. In the EOW, EOW is the first matter, my lords, which is EOW coal. So in that, my lords, there are 19 persons, accused persons.
Where it is mentioned EOW?
Right there it's highlighted, it's not highlighted, my lord, sorry, it's in the EOW ACB is FIR number 3, 2024, dated 17/1/24. In the dark portion, my lords, coal, then it says. Thereafter, my lords, is the ED's ECIR based on this. Next page, my lords, page 2. Again, I have indicated the period undergone and before your lordships were pleased to. Then is the third part is the EOW's FIR in DMF, which is serial number 25 onwards. Mineral Fund. There also, my lords, and the ECIR based on the DMF scam. And then there is one DA case at page 3.
No, just a minute.
Sorry.
One EOW and the next number 3 are different cases.
Yes. So EOW is one is coal, then is the ECIR in coal, my lords. Then is DMF, EOW, and based on that EOW, DMF. So there are two separate predicate offense and two separate ECIR, my lords.
So from serial number 25,
yes, lord.
This EOW is in
It's in DMF, my lords. District Mineral Fund.
That
DMF it says, my lords.
as they call it liquor scam.
No, it's DMF. It's a mineral scam, my lords.
Mineral fund below. Mineral fund. They say mineral fund. Mineral fund.
Fund.
Yes.
And these
First is
one
coal, my
the coal,
Yes, my lords. First one is coal.
and then this EDR matter is also pertaining to coal.
Coal, my lords.
Second, then EOW is mineral.
DMF, my lords.
And ED also.
ED also of DMF.
Yes.
Then there is only one other DA case against one Ranu Sahu, my lords. It's a disproportionate asset case, my lord. Just above 40, your lordships will find that, serial number 40. And there is one of the liquor scam, which is 41. It's not, it's connected with this 19. But liquor is supplement,
Liquor is separate item.
separately listed also, but it's,
Deal with that separate.
I've only given the serial number in 19. my lord.
Correct.
So this is wrongly tagged with that 19 bunch because liquor is not arising out of this. And go with the Lakma matter, my lord, because that deals with the liquor part.
No, the item 41 will go that way.
Yes.
41 will be shifted to other.
Yes, my lord.
Yes.
41, Baba. You have some 42. 42 will go to
42, 41. अब ये बता देना किसको कितनी मिली हुई.
So, my lords, please see, we have, your lordships have been pleased to enlarge page one. Most of the persons, my lords, from on interim relief for, and they had all undergone a substantial period of time overlapping between the ED and the predicate offense.
Whom we have not granted from 1 to 18?
Everyone has been.
Everyone has been granted.
So let us only identify those whom we have not granted.
There are none.
My lords, there is one, 19.2, Dipesh Tong, serial number 2, not arrested and but
Whereas he was not arrested, Deepesh Strong.
All the 40 matters, the list which you have given.
yes, my lord.
All we, in all matters we have granted interim.
Yes, yes,
That is the question.
yes, my lord. And we are only playing, my lord, that your lordships may be pleased to confirm that order now. Because if your lordship sees the, just one moment, if your lordship sees the period undergone, my lord, from the ED, because in the ED, like in coal, people who are in custody for 1 year, 9 months, at serial number 21, if your lordship sees, Soumya Chaurasia, 1 year, 9 months, then Suryakant Tiwari, 2 years, 7 months, Sameer Vishnoi, 2 years. So people had already undergone a substantial period, then they were taken into arrest and arrested, my lord. So maximum is, they've all undergone, my lord, 7, out of 7 years, and voluminous record by the prosecution, trial has not commenced. All those things are there, my lord. I'm only praying for, and so many accused persons, charges not framed.
In all these matters, we impose the condition that they will remain out.
Yes. No, only for some accused persons.
Some of
that
5 of them.
there is Soumya Chaurasia, my lords, Ranu Sahu, some of them. The main, the ones that your lordships went, sorry.
DMF.
Yes. Yes.
But that condition is only in EOW DMF.
No, coal. Also in coal.
No, not in coal. Coal order of granting interim bail is earlier, my lords, that's 3-3. These were granted on just on 29th before closing, my lords, in the summer vacation, last summer vacation, on 29/5. So therefore, your lordships were pleased to impose that condition that stay out of that and go wherever. Be that as it may, my lords, anyway, this Soumya Chaurasia has now been arrested by them.
I will deal
That's
with
a
it.
separate matter also. So even after complying with that order, she's been arrested. But that be that as it may, my lords, for others now they've substantially, and there's no allegation of misuse or anything apart from of the bail condition that your lordships are pleased to.
Soumya Chaurasia is a woman or?
Woman.
Yes.
She was the deputy secretary of the chief minister.
Soumya is a case where your lordships have repeatedly granted her bail and repeatedly she is arrested. It's a case of evergreening of arrest. Because Soumya has now been arrested on 16th of December 2025.
The liquor matter.
Complaint has been filed on the same day. She was granted bail 3 times, my lord, by the Supreme Court. In coal scam,
in Milord EOW, ED, and Milord the mineral.
Moment you grant bail, Milord,
The moment bail is granted, Milord, this happens.
arrested.
And Milord, she has that condition that she has to be outside. She came into the state, Milord, to attend a hearing, and she was arrested. Now, she is a lady, Milord, she has suffered so much. She is the serving officer. Your Lordship's order is that she will remain suspended till all this is over. So she is not, Milord, working for the last 3 years or so. She has been arrested, Milord. She has spent 2 years in jail. And now, Milord, again 2.5 years in jail. Again, she is arrested. That is, Milord, item number 25.1.
That's liquor. That's not.
Yeah, now in liquor.
Liquor case.
Yeah. So liquor, Milord, if you Lordship note, liquor is item 23, 24, 25, and 25.1. 23.
That means there is no bail in item 25 and this matter.
That in 23 and 24.
So I am explaining, 23 and 24 relate to one person, which is Kawasi Lakhma, who was a minister. So 23 is, Milord, 23 is, Milord, the EOW liquor, 24 is ED liquor.
It's only for 9.
This start, Your Lordship.
This is only item 9.
Another one now. Sorry,
This is only item 9.
This is only 90.
It may be convenient if we and the PMLA matter relating to coal and DMA.
Right.
Because there can be a reasonable.
That's correct. I follow.
These cases are cases where all before us are on interim bail.
Yes.
And the question is subject to hearing the state and ED whether we confirm those.
Right.
Then we take up those cases.
Fair enough.
People are,
Only thing is, Milord,
some of them on interim bail, some of not.
right. Only, Milord, I go down to what Your Lordship says. Only thing is, Milord, even in the liquor, Milord, they put in 1 year already. And Soumya, Milord, has put in, as Your Lordship, of more than 2.5. So, Milord, liquor also urgently, Milord, rise for relief.
We are laying it down that first we considered the confirmation of the interim bail in DMF, coal, and the related PMLA cases.
Right.
Then we go to liquor.
Fair enough.
But that will not again push it, Milord.
No, same day. One by one.
Of course.
We are hearing one by one today.
That's fine, Milord. I thought, Milord, they will go. No difficulty.
Not for delay or anything.
You may indicate the number, my lord. You may indicate the number so that I may then know what matter is.
So, Mr. Raju, first is the FIR number 3 of 2024, dated 17th January 2024. These are all EOW matters arising out of that alleged coal scam.
EOW, I am not appearing.
I appear for EOW.
He appeared for UW coal.
Correct. In all these matters, you are there?
Yes,
Okay. Now, we have granted interim bail. Any serious objection?
With regard to some of the individuals, we have no objections, whose roles are minimal, who are just a company.
First of all, tell us those who are those lucky draw.
No, we have also made a chart for my lord's convenience. If my lord, I get powers.
It will become easier. Yes, please. We will exclude those matters. As per this, your chart.
Yes, Malas.
You must be having objection one with regard to this Ranu Sahu.
Malas, I have objection to Ranu Sahu.
All right, sir. But with a smile,
Malas, my lord sees the chart I've handed over, Malas. If my lord sees the chart I've handed over, what I've also done is I've also culled out the role of each of the accused.
You've got the chart handed over by Mr. Dave.
Yes, Malas, I have that.
Have
I'll
it?
just correlate.
You just check that chart and say which person's serial number you have objection.
Malas,
Your chart. Yes, on the chart.
Kumar Singh.
Ranu, you have objection.
Ranu, I have objection, Malas.
Very good.
They have.
Let us go further. Then Soumya, you will have objection.
Soumya, I have Hemant Jaiswal, I have objection, Malas.
No, there are number of people between Hemant and Ranu.
So, Ranu Sahu, I have objection, Malas. Deepak.
So, what about Deepesh Tonk? No objection.
Malas.
We are not recording. Don't worry. We will not record any.
Deepesh Tonk,
was only a facilitator. He
No,
was,
sir, let us do like this.
yes or no? His role, he can be,
Now is a marginal,
confirmed.
is a marginal player, all right?
Yes, Manas.
Now, so is Rahul Singh,
So is Rahul Kumar Singh.
so is Shiv Shankar.
No, Manas. Shiv Shankar Nag is a very.
You have an objection in Shiv Shankar, okay? Then Hemant,
I have an objection, Manas.
you have
He's
an
equal partner.
objection in Hemant. Soumya Chaurasia,
Manas, I have objection.
you
Soumya.
objection in Hemant. Chandra Prakash,
Manas, I have no objection.
no objection.
Chandra Prakash.
Sandeep Kumar,
Sandeep Kumar Nayak, Manas, I have objection to Sandeep Kumar Nayak. He's also.
Roshan Kumar Singh,
Manas, no objection. Roshan Kumar Singh.
Sheikh Moinuddin,
No, Manas, no objection.
Surya Kantewadi,
Yes, Manas, I have objection.
you have objection. Samir Bishnoi,
Yes, Manas.
yes or no?
Yes.
They'll have.
Parekh Kuya,
No, Manas. We have no objection.
Virendra Kumar Jaiswal,
No objection, Manas.
Lakshmikant,
No objection, Manas.
Manish Upadhyay,
No objection, Manas.
Nikhil Chandrakar,
Yes.
No objection, Manas.
Rajnikant,
No objection, Manas.
then Navneet Tiwari,
No objection, Manas.
no objection. One, two, three, 4, 5, 6, 7, 7 zero.
In 20, there is no interim order as yet.
For the first time for your lordships.
In 20,
In item serial number 20,
no, we are just up to 19 only.
19, yes.
They have not come
Yes,
because this is the whole predicate.
your lordship.
So in this whole predicate, so we have this chart.
Sorry, Miller.
We have some extra copy of this chart.
Yes, Miller. Sorry.
The serial number,
So
they have not been able to put this.
just now, this Mr. Dave chart, write down. This will be item number 2, 3, 5, 7, 9, 10, 12 to 19. So these special petitions have been filed, challenging various orders passed by the High Court of Chhattisgarh whereby the bail application moved by the petitioners in FIR number 3 of 2024 dated 17th January 2024 registered by Economic Offence Wing of Chhattisgarh Police Station so and so in bracket known as coal scam. The aggrieved petitioners have approached this court seeking bail inter alia on various grounds, but most of them submitting that they have already undergone 8 months to more than a year period in custody, and the investigation still being incomplete on account of filing of supplementary charge sheets. The commencement of trial will take time, and hundreds of witnesses having been cited, the conclusion of trial will take some years. Next paragraph. After considering the nature of allegations attributed to these petitioners, but most importantly, keeping in mind the period already spent by them in custody, this court wide interim orders dated 3rd March 2025, 29th May 2025, उससे पहले तो देना 1st May 2025, then 29th May 2025 and 12th July 2025 granted interim bail and ordered the petitioners to be released from custody subject to certain conditions. Subject to certain the following conditions. Subject to the following. What are the conditions imposed?
In these ones, no.
Probably not, no. Release, please. Next paragraph. We have heard one senior counsel on behalf of the petitioners, as well as legislative counsel, who vehemently oppose the grant of bail, comma, highlighting the gravity and magnitude of the coal scam in which the petitioners have been implicated. He also highlighted that how the petitioners have played their respective role in collusion, in alleged collusion and connivance with the principal accused. On a query, next paragraph, on a query, comma, Land State Council, however, does not dispute the fact that after that there is no instance of misuse of the interim bail granted to the petitioners by this court. So, taking into consideration the fact that the petitioners have already spent 8 months to over a year period in custody. 2I, the final charge sheets are yet to be filed. 3I, the commencement of the trial itself may take some time. 4I, the prosecution having proposed to cite hundreds of witnesses, comma, the conclusion of trial will take time, coupled with the fact that the petitioners are not accused of misusing the concession of interim bail, comma, उनमें समय पहले लीव ग्रांट करके अपील करना. We allow these appeals, set aside the impugned orders of the High Court, and direct the appellants to be released on regular bail, subject to their furnishing bail bonds to satisfaction of the trial court. In addition to the conditions that may be imposed by the trial court, it is directed that 1I, the petitioner shall deposit their passport with the trial court. 2I, they shall also furnish their contact numbers to the investigating officer, stroke the jurisdictional police station. 3I, they shall not make any direct or indirect attempt to influence the witnesses. 4I, they shall remain present before the investigating officer, comma, if so required, and shall fully cooperate with the for conclusion of the remainder of the investigation. Then say main paragraph, order according. Any other condition?
No, this is subscription.
Order according. Right. Now comes this order shall dispose of SLP criminal number 15941/2024, 145/2025, 167/2025, 944/2025, and 1680/2025.
And 1896.
1896 Mulas. 1896 next one of 20.
Serial number 12.
Samir Vishnu Mulas.
Serial number 12 also they have objection.
They are objecting.
Yes.
Samir Vishnu, you are objecting.
Yes.
Mulas, his role is serious. Although he has been cooperating since his release on interim bail. And his
take cooperation, why unnecessarily?
His role, he was the charge. He's cooperating, so let him be on interim bail.
No, maybe that wrongly I included him in the list of those where you have no objection, and that number has gone there now. So that is now locked. Kaun banega crorepati?
He was the head of the department, and it's only because he is on interim bail that he has now been providing us with crucial leads.
So long as you see the suspects are cooperating, you should have the advantage of that cooperation for the purpose of taking your investigation to a logical conclusion.
Yes, Mr. That's
not asking you to record confessions or anything.
No.
But this will help you to complete the investigation.
Yes.
And take that advantage.
Milord, I beg to appear for Samir Vishnoi.
All right, thank you. Thank you. Now next, ये हो गया sir?
Milord, 19.37 has been missed out.
Say leave granted. Madam, we have included your client already in the list of those who bail confirmed.
Thank you, Milord. Deeply obliged.
Then say leave granted. Then say these appeals, these criminal appeals have arisen out of FIR number 3 of 2024 dated 17th January 2024. Then was the first paragraph pertaining to alleged allegation known as the poll scam. The appellants approached the High Court for the grant of bail, but the same having been declined through various orders, comma, they approached this court in the instant criminal appeals. So that's further. It may mention that while interim order dated 3rd March 2025, third, and this is also third, and this is also third, this is also third. All that third, 29th May 2025, comma, the appellants were ordered to be released on interim bail. They are still on were released on interim bail. However, there been on strict conditions because it were released on interim bail subject to the following conditions. Then say regardless thereto, London State Council vehemently opposed the grant of bail to them. We have thus had London Senior Council, Stoke Council for the parties in support and against the prayers in these appeals. Now, this is the only format. Now I will hear you.
If my lords may
two lines star up.
My lords, I have given the note, my lords. If my lords may just can refer to the note that I have given. If my lords may refer to the notes that I have passed on, Mills. So, Mills, here role of each of the accused. I've tried to summarize it, Mills. So, Ranu Sahu, Mills, she was appointed by the cartel as collector first of Raigad and then of Korba Mills. There are two most coal-rich districts in Chhattisgarh. Mills, she being the district magistrate, she ensured that for per ton 25 rupees is collected, and additionally she collected 2 rupees extra for herself. Or she made sure that none of the transporters or traders are.
So after collecting this, yes, she passed on this 5 crore 52 lakhs to Suryakant Tiwari.
Mills, that's the as per the diary entry. What she has passed on is 5 crore 52 lakhs, which is reflected in her name.
And while we understand and appreciate your contention, when a person will indulge this kind of corruption, assuming that allegation is correct, we are only hypothetical basis that if a person in a position indulge in this kind of corruption, and if he or she becomes conduit for collection of the bribe money for any higher or superior or any authority, obviously, in addition to what they will be supplied, something will all be pocketed by that corrupt fellow also. Because why somebody will do corruption as a social service for others?
Absolutely, Mills.
So they will, when your hands are so dirty, obviously that you will collect something for yourself also. We understand that part.
She has purchased 68 acres of land, tribal land, additionally. And that the diary entry, Mills, does not record all her transactions.
So 5 crore 52 lakh supply is
correct.
Assuming assuming another 5 crore was equal to 50% applied, 50% pocketed. So a bungling of 10 crore or so. So how much the property you have attached?
Malas, we till today have identified her properties, 68 acres of land that she's purchased. She's her other immovable lands, if my lords may have para. This entire chart furnished, Malas, of her.
You have attached those properties, right?
We've identified it. We have identified.
I did not want to interject.
You don't, wait, sir, wait.
So all that properties 68 have been attached.
So you have attached those properties.
We have attached those properties.
The purpose of investigation is complete. Your note also says the investigation is complete so far as Ranu is concerned.
Malas, the only issue is this, Malas. Investigation qua Ranu insofar as her role in Korba district is complete. But what's going on is her role in Raigad district. How much she and how she facilitated that's ongoing.
This is what we will also strongly recommend you, that you must investigate her role. There is no question of any, if a public servant has indulged in this kind of thing, you, not only in that district, wherever you find that, yes, there may be other districts also, where in Chhattisgarh we don't know where the mining, coal mining are there. But you definitely investigate that part. But what is the impediment being caused in that investigation?
Well, the issue is this, if my lords may see, what she has also done, Ranu Sahu, there's a reason that she was posted in those districts because of her proximity to the very powerful corruption cartel in the state. That was the reason why she was posted. What she has also done, apart from, no.
She is member of IAS or State Civil Service?
State, she's an IAS officer, Milas. She's an IAS officer.
Then, you see, whosoever will be the regime, one IAS officer will be posted as collector.
Yes.
Because under the cadre rules, under the IAS cadre rules, the post of collector is one of the cadre posts. So whether this Ranu Sahu is posted or present person is posted there, posting itself may not be a relevant factor. Indulging in corruption is relevant.
No, Milas. I agree, but she was posted both in Rich state only to facilitate that.
Posting part can become a part of the some scandal. Suppose a person is a member of the State Civil Service, not promoted to IAS, but just to give undue favor to that person, he is posted against an IAS cadre post.
Yes, Milas.
If that happens, or a person is working, let us assume a deputy commissioner of excise and taxation, he has nothing to do with collectorship. He is brought, hijacked, and a handpicked person then posted as collector. Then one can draw some remote inference that the object of bringing this person instead of posting a regular cadre officer was some to secure some illicit, benefits through him.
Absolutely
Understandable. But an IAS officer posted as collector is not a sensational issue.
No, then this her conduct subsequent thereto, how she acted.
That is what.
Her conduct thereto, Milas, she also, Milas, what she also did, she got the land, she got coal washeries extorted in for Surikant Tiwari. We have statements of businessmen that, and she got land deals done at 12 midnight at midnight by directing the registrar to open the registry. So she's capable. She's just not. She's capable. She has influence. She knows how to yield influence. Milas. If my lords may see point number 3 of my note, Milas. Throughout the period, she was in active communication with Surikant Tiwari. Roshan Singh helped the cartel to collect. And additionally, Milas, she also she forced the owner of one of the washeries to sell it to Mandwarni coal beneficiation to sell it to Surikant Tiwari.
See, these are all, as of now, these are allegations. Allegations of serious nature of impropriety, corruption, misuse of power, abuse of the position, and exploitation of the illicit or illegal exploitation of the state revenue and property. Understandable, these allegations. Eventually, you will have to prove these allegations.
Absolutely.
Today, we are only on the limited issue that having granted an interim bail And if during this period there is no instance of misuse of concession of that bail, how to balance the liberty vis-a-vis your ongoing investigation that should not be affected?
Means just one thing, in that case, what I propose is this, they are anyways on interim bail, means let them continue on interim bail, give us 2 months time to let the investigation be open, means we'll complete the investigation.
Right on. Now we understand your apprehension, so we'll take care of that. That some of the appellants, like Ranu Sahu, are involved in multiple cases, and the nature of the case has done, as having highlighted by the State Council, are quite grave and serious in nature. However, applying the yardsticks which we have followed while disposing of a batch of connected appeals, we are reminded of the fact that these appellants too have spent reasonably long period in custody, and there is no instance of misuse of concession of interim bail by them. We are cognizant of the state's apprehension that given the full liberty, we are cognizant of the state's apprehension that some of the appellants are affluent, affluent that they're indulging, that they are capable of influencing the star witnesses, and or they can indulge in the destruction of evidence. Keeping this apprehension in mind, and ensuring a fine balance between the liberty on one hand and fair investigation followed by a clear free trial, a transparent and clear free trial, we allow these appeals subject to the conditions already imposed while granting interim bail. Also, we further clarify that during the pendency of the trial, till the deposition of all the vital witnesses, the above named appellant shall remain outside, shall stay outside the state of Chhattisgarh. They shall enter the state only a day before the date of hearing, when they are required to appear in person. The trial court shall not grant any exemption from personal appearance to the appellants, except in a case of the health emergency, or the appellants or their advocates shall not make any attempt to contact the prosecution witnesses and or any such attempt to destroy the prosecution evidence, to tamper with the prosecution evidence. Next paragraph. The appellant shall not shall give the contact number to the jurisdictional police station of the EO wing of Chhattisgarh police. In the event they are required for further, if they are required to join the investigation further in the pending investigations, they shall appear before the investigating officers in person and shall fully cooperate with the ongoing investigation. Next paragraph. The appellant shall not be permitted to travel abroad without prior permission of this court. Next paragraph. In case the appellants are found involved in influencing any witness and or tampering with the evidence, liberty is granted to the state to approach this court for cancellation of bail. I think that's
Just
so
one,
these 19 matters are disposed of, right?
just one prayer, sorry.
Now we come to 22, 24.
Manoj, in this,
These are PD matters. Based upon these very facts, Mr. Raju.
Put 19.1.
Granted, the 19.1 is, 1 is 18%.
But there are some 19.1, 19.11. May I just hand over the chart?
Right, today in the cause list, Mr. Raju, 19.1, 19.11, 19.14, 19.21 and 19.26.
26 and 19.30 also.
30. Just 30.
But 19.17 and 18 I am not appearing, Manoj.
Is there any serious objection in 1, 11, 14, 21, 26?
1, 11, 14, 21, 26, 30. No, I have no objection. 31 is, 21 is different, Manoj. No, therefore I have no objection. I am not appearing in 17 and 18. Ms. Bharti is appearing in 17 and 18.
So this in this chart of Mr. Dave, serial number 20 to 24, not a serious issue. We can confirm.
My lord, 21, 11, 1, 11, 14,
21, 26.
21, 26. No issue. No issue.
So 20 to 24, the leave granted, the appellants are accused in ED, in ECIR number RPZO stroke 09 stroke 2022 dated 29th September 2022, which has been registered by the Directorate of Enforcement. Most of the appellants remain in custody for more than or nearly 2 years.
For enforcement director.
2 years. The court. This court, while orders dated 25th September 2024, 29th May 2025 and 29th May 2025, release them on interim bail. Next paragraph. What is the position of the charge sheet in the predicate offences?
They are all filed, my lord.
Predicate offense I am not aware.
Predicate offense in which matter, my lord?
Not DMA.
Coal.
The coal.
Coal. I am only in liquor. Much more.
Then you sit.
4 charge sheets were filed. No.
DMF?
DMF was in 1 or 2, but my lord, I'm not, they are all on interim bail, so it's all right.
So we have filed 4 charge sheets in court. We have filed 4 charge sheets, 1 mail, 3 supplementary mails.
So we are informed that in the predicated offence cases, in some of the in the case predicated offences, some of the cases charge sheets have been filed, whereas some investigations are still pending. Also, in the complaints in the statutory complaints filed by the enforcement directorate, there are hundreds of witnesses cited who are required to be, who are supposed to be examined for taking pending proceedings to a logical conclusion. The trial will thus take a reasonably long period. The appellants have already spent nearly 2 years or nearly or more than 2 years in custody. So, there is no instance of misuse of the concession of interim bail, taking into consideration all the attending circumstances, or without expressing any opinion on merits and opinion on merits. We deem it appropriate to confirm the interim orders dated so and so. Thank you. And entire notice also, and the plans are accordingly released on regular bail, subject to the conditions already imposed on them. Any additional condition you think?
Passport to be surrendered.
Passport, yes, and that condition is valid. Passport valid, that condition is not valid. Now comes item 25 to
DMF, my lord.
first is DMF, yes.
But also take him 21, well, 21 is not a bail matter, but it's a
21?
21 of the writ petition by Anil Juti.
We'll take it later. 21 of the main
item.
call this. We'll come to that later.
You charge.
21 is serial number 33 in this list. Mr. Dave, in your list, item 21 is today. So we will take up this separately. And others can be done.
Which is mine.
And who is representing the state in these matters?
I represent the state.
Now tell what is the position in this matter?
Means we have filed one charge sheet. Means we intend to complete the investigation by March. In DMF, I have that instruction. Means
There any serious objection against the confirmation?
Means against Surikant Tiwari, Soumya Chaurasia, I have objection. Means
Surikant Tiwari and
Soumya Chaurasia. Means
Soumya Chaurasia.
the other officers, Melis, what they did was this DMF, Melis, let me give a background. This is a very serious. What they have done is officers, Melis. What they've done is this is a fund, district mineral fund, which has been established under MMDR Act. Melis. The entire object of this fund was that the mining areas should be paid back, should be compensated for the extraction that are made. What these guys did, these officials, they floated false tenders, non-existent tenders were never executed. There's no work done, and monies which were meant for development of tribal areas, were all siphoned off. And all officers, they are all government officials, contractors.
Our only worry is that FIR is of January 24.
They are, in DMF, I am saying, I've got instruction, we'll complete the investigation in a month's time. Malas will give up 45 days, we'll come, and then
we are not, that's why, you see, sometimes fixing a timeline for completion of investigation can cause very severe prejudice to prosecution. Because your officers will be under pressure, they will hush up everything and will file the charge sheet. Instead, that's why we keep on balancing these things. Interim bail, they are there. We are not on these two. We do have a separate kind of language and tone and tenure of the order. But about the remaining...
The issue today is, and why I said that investigation is about to be completed is, we are getting the statements of various contractors now, and it's in under process as we are intending to file a charge sheet of various contractors who awarded these tenders.
So pattern रहेगा, ये जो होगा, FIR number 2 of 2024, dated 16 January 2024, pertaining to the alleged DMF. This is DMF means
district mining fund, mineral fund.
District mineral fund, the alleged defalcation and misappropriation of the district mineral fund. The aforesaid FIR has also been registered by the Economic Offence Wing of the Chhattisgarh Police at police station so and so. Then item 25 or 27 question must improve करना. This is 26 ये chart में 26, 28, 29, 30, 31, 32, 33 फिर include होगा
33
and 34. So तीन निकल जाएंगे इसमें.
But 34 is not 30. See, not 34.
34 is a very small level. So these matters में जो first order किया ना, change these are the allegations. And about the remaining two, this is 25 and 27, separate order, vehemently opposed, all their contentions and bail order confirmed, subject to the condition that they will remain outside the state of Chhattisgarh. They will not enter the state. Condition. So we have reached in this chart up to 33 will be separate. 33 will have nothing to do. It's a separate condition. Now remaining matter we take tomorrow.
Well, it's only one sentence. Your Lordship is rising. Your Lordship is rising. Item 13 tomorrow in your Lordship's court. both advocates on record and both seniors requested the registry not to have it tomorrow. It still come on the board. We are with consent requesting for Monday. Item 13 in the Lordship's court tomorrow. It's a fresh matter. Both sides have agreed that it may not
That matter is listed tomorrow.
Yes.
You don't want tomorrow.
No, because we are not here, Manoj. We are
Instead of Monday, tell us some other date.
Then Tuesday, Manoj, or Friday?
Tuesday, Wednesday, no.
Tuesday.
In our matters,
Liquor.
liquor matter. There are two matters which we are concerned with.
No.
One is whether
Item 13 is noted, Manoj. That's
in this matter. In this matter.
Today's listed.
today's listed matters. Today's listed matters, there are also two matters concerning the liquor excise scam. One is a bail which I am opposing, a bail which I have challenged. That may be kept on the 3rd along with a bail which they want for the excise minister. These two, one bail which they want for the excise minister and one bail granted to the chief minister's son, which I am opposing. We actually keep both those on the 3rd.
Both of those matters you want when?
On the 3rd, next Tuesday.
Next Tuesday.
May I?
Those two matters next Tuesday.
May I mention serial?
Just a minute. All these matters, we are talking of Chhattisgarh matters.
Not on that.
All the remaining matters will be tomorrow, except these two matters which Mr. Jetblani has pointed out. These matters will be listed on 3rd.
That's not.
Just a minute. If you want any other matter also not to be taken up tomorrow, and you want to be taken up on 3rd, you can point out.
I'm sorry, Manoj. Manoj, I'm sorry on the.
This will also.
That can also go.
Manoj, I am the.
Say diary number 3.
Manoj, not on the 3rd, Manoj. I'm in that matter.
35985 of 2025, Anil Tuteja versus ED. This is also, you want to file your reply?
Reply will be filed today.
You are
ready, will be filing it.
They have not filed a reply. This can also come up with that Swami
Manoj, not on the 3rd, but on Monday, the following Monday, Manoj. I am opposing that matter.
No problem. We will accommodate it.
Following Monday.
21, I'm appearing, Manoj. That can also be.
Not on the 3rd, the following Monday. Yes.
The counter affidavit can be filed during.
What is the date, the following Monday?
During this week. Post this matter on 9th February.
9th February is fine.
This is the
issued at least, notice may be issued.
Why notice? Manoj, your lordship.
No, my lord. We have serious objections in relation to issuance of notice. You have to hear us on that.
Anil Tuteja.
This is the cancellation matter.
Anil Tuteja matter we are.
That Mr. Alam is appearing, Anil Tuteja.
Manoj, I am appearing in 21. This is Anil Tuteja's matter. Manoj, that matter, they are taking time to file a reply. This is identical to Soumya Chaurasia.
Notice in this matter.
Your lordships have, Manoj. Therefore, they are taking time.
Today, item 21 notice has been issued. A reply, counter
Filed today, lordship may keep it on any date. I don't.
Manoj, with Soumya Chaurasia's matter, it's an identical.
9th February.
9th, that's fine.
Soumya Chaurasia's matter.
Well, your matter is which one?
That's the Chaitanya, the SLP.
The one in which I'm also appearing, my lord.
Cancellation of bail.
Cancellation of
your lordships were in fact wanting to dismiss, but he said to have it on another day.
That you want on 9th. So then instead of 3rd, we can take both the matters on 9th February.
Yes.
My lord, in that liquor issued otherwise, in the matter of Chaitanya.
They are already there.
Lord, I
They have to file a reply, not. I don't mind if you don't want.
No.
What
My lord, your lordship is supposed to hear on the aspect as to whether notice is to be issued on that.
Notice has been issued. Why?
On the last date of hearing, your lordship was inclined to dismiss it.
Exactly.
No, my lord, that's not correct. It's not that matter. It's not.
You were very much there, sir.
Anyway, there is no notice issued. Where's the question of reply?
Mr. Hari, and the judges are always unpredictable.
I agree, my lord.
When we are hearing you, it looks like what you are arguing is correct. Therefore, we will say yes. When Mr. Jetblani will argue sometime, no.
But lord, but that bail in Chhattisgarh, both of us were heard and then it was granted.
But anyway, Manoj,
so there was no
notice has been issued
there.
on cancellation. No notice need be issued.
So either will the remaining the left out matters are either tomorrow.
Tomorrow, my lord.
You can give a date. If you don't want tomorrow, then if you want 3rd, those will be taken on 3rd. If you don't want 3rd, you want on 9th, you take on 9th.
May I
That's
32, my lord. There's one more matter, my lord.
That
One more
item
matter, my lord.
47 and 48, that Bengal matter, Manoj. Dola Sen and Tamil Nadu matter.
Part third.
Manoj,
That theft of an idol.
The problem is, Mr. Mahesh, we are near completion of that SIR matter. We are hopeful today that matter might be completed.
Manoj, 47 and 48 are Dola Sen and the Tamil Nadu matter, Manoj. Manoj, 47, 48 is Dola Sen and the Tamil Nadu matter where your lordships had to pass this same order.
we are hearing this SIR, and as and when you want, we'll take up those matters also. Once it is over.
2 p.m. your losses may take it up, Manoj.
2 p.m. first, that part of the matter will be continued.
But we need some urgent orders because of the problems created.
This Lakma,
So that temple matter, when is your lordship keeping it, man?
It's a fresh, it's
item 26.
We'll give a date of your choice.
no, this Lakma,
Well, can we have it on the 10th? 10th?
Item 33 may be kept on 9th.
Maybe not on 10th week, better 1 week more.
17th?
17th.
this Lakma's matter 20.
Number 32, my lord.
Tomorrow, my lord.
32, my lord, may I?
My lord, we have it.
My lord, 23, 24 can be kept for.
Bombay, my lord, has specially come for this matter, my lord, your lordship.
Which item?
32, my lord. The other side has not filed a reply as yet. It's an interim application for security. I have a foreign award in my favor. My lord, I was requesting your lordship to give us a date and direct. If Mr. Singhvi appears in 32, permit him to, my lord,
Manoj, let,
Today we can't take up the matter. We are in the middle of a part of matter.
Manoj,
give us a date then, my lord.
Please tell us which date. Please tell us date.
10th of February, my lord.
10th February, we have already listed some matters. We don't want to, you to.
17th February.
How much 17th?
Manoj, then
Reply, your lordship. Direct them to file a reply.
We take your matter on 18th instead of
46 is fresh.
That's spreading the matter.
18th, I'm in some difficulty, my lord.
19th.
Manoj, fight him 30.
then let 47, 48 come tomorrow, Manoj.
My lord, 19th.
If your lordships are not going to take it today, let it come tomorrow morning.
My lord, 1932.
19th.
My lord, the other side may be requested to file a reply.
Item
Lokshmi is there. Lokshmi is there.
We served them in September.
19th February.
We served them in September. They haven't filed a reply as yet, and I've been granted liberty to file this application.
Properly, he's talking of some fresh application, your lordship, not.
Yes, of course, but we've been granted liberty.
Manoj,
Manoj, 46 is fresh.
47, 48.
Item
may have it
33,
tomorrow, Manoj.
17th, the other side is
floating match.
item 33.
Item 33.
Manoj,
Item 33, when do you want?
Manoj, 47, 48, your lordships may have tomorrow then, Manoj, because the draft roll is going to be published on the 30th.
46 also,
So,
Manoj.
Manoj, at least tomorrow, then we should have some.
All right, tomorrow.
46 as well, Manoj.
My lord, 25, still number 25 on the 9th, my lord.
SIR matter, interim relief matter tomorrow.
Because item
25 and 25.1 on the 9th, my
from
lord.
this March, it is coming up for the first time.
Yes.
Like.
Lord's permit minutes. Items 47 and 48. It seems Mr. Sibal mentioned it concerns Tamil Nadu SIR and they wanted it to be listed tomorrow. Could it be day after tomorrow minutes? Because of my difficulty tomorrow, I am unavailable. Day after tomorrow, if my Lord's convenience suits. We have informed the other side as well, Mr. Sibal.
The problem is the last day for filing objection and claims is the 30th, Malaj. We have listed this application several days ago, Malaj. Every time it's this, otherwise means we will be faced with a fait accompli. And Malaj, in Tamil Nadu, the same order is to be passed as was passed in West Bengal. It's the same logical discrepancies. The same order is to be passed.
You can have instruction, Mr. Naidu, that because once we have laid down some uniform guidelines.
Yes, Minister.
For West Bengal, there is no reason, as it appears to be, that why those very guidelines be not followed in Tamil Nadu also.
That's all.
So, in fact, no order will be required.
Exactly. We are
In
just
fact,
asking for
Millet
the
is
same
coming for
order,
the
Malaj.
first time.
But those guidelines are broadly, there is,
Got the order here.
Even we need to join the issue, Millets. We need to file our pleadings as well. It's coming up for the first time.
No, but it's the
So that
same
it could be
logic.
had day after tomorrow, so that we'll come up with our defense too.
tomorrow is not
Possible.
So we have served you this copy some time ago. 21st we served
Then
you the
Millets-
copy. You should have had the answer for it.
Let it be there on Monday, Millets. If my lords, for whatever reason,
Date will be
could
over.
impress upon your lordships that it needs to be.
You can extend 1 week time for filing objection. If we
I cannot.
Can't have it both ways.
start filing 1 week.
Millets, in fact, the law is, as my lords have appreciated, they can file their objections until the date of nominations. Though electoral rolls are ready, they still have their options.
Bengal,
Yes.
West Bengal order.
Just pass the order. We can do it on Mondays. That's not an issue.
Present.
In Tamil Nadu also, there are 3 categories.
Yes, Malaj, in 80% of them, Malaj. Same thing, same application, the same facts, Malaj. It says, Malaj, it's very interesting, Malaj, that delivery, Malaj, notices have been generated only for 18 lakhs. There's a gap of 88 lakhs.
8%.
88%, which have not even received notices.
With all these figures, Millets, we need to counter that one.
We have filed.
And for that also it needs to be,
The first we served it on you. What were you doing all these days?
it's coming up today.
You can't be making it that the statutory scheme can be just bypassed because you're not available. That's not fair.
That's your version. Let our version too come on record.
You should have filed the reply by now. It's not fair.
No, but these are very general. You see, first is the documents brought on record by the parties indicate that within the category of local logical discrepancy.
Yes.
These are kind of discrepancy.
Yes.
Then with a view to enable the person, first is the names of the person figuring in the logical discrepancy will be displayed.
Right.
The Gram Panchayat 1%.
Let's, then Millets, let it be taken up tomorrow. I'll seek instructions. Only Liberty Millets, I may be permitted to appear online. That's all. Wherever I am. That's the only indulgence I could crave for. If they feel that's so urgent, let it be, then I'll appear online.
Otherwise, yes, you can have tomorrow. You can appear online also. Even your junior or assisting counsel, he can point out. So the first thing is, we will display. You yourself said that Mr. Dwivedi had earlier pointed out that you always display them. So
Yes, yes.
Then those persons who are likely to be affected, they can submit their document themselves or through authorized representative. That's you can't any possible. Documents may include. Documents may be permitted to be submitted in the Panchayat 1 or block offices. That you are again you do it. The election commission will issue instruction. Time there we had granted 10 days. This 10 days will start from tomorrow. They can submit there from once they are there. Or if you can have instruction, we can take it up 4 o'clock.
Tomorrow, Millets. I'll seek instructions because it's sufficient. They need to have the hierarchy.
All are general orders.
So wait, tomorrow.
Tomorrow.
Great.
And the West Bengal matter also, Malas. West Bengal matter also.
48.
48.
What is left in West Bengal matter? The directions are already there. Mr.
No, Malas, they have done something more. They've done something more.
Something will continue.
No. In fact, Malas, it's far more serious. What has happened there is now
Then this has become endless exercise, not turning this court into an
But at least, Malas, your losses may, if not tomorrow, have it on Monday, because at least there the date is till the 7th. Let them file a reply.
No, but we will grant them breathing time. We can't wait. Mr. Sipal. We have already issued comprehensive directions.
But Malas, that doesn't apply to what is happening now.
Every day something will happen. We know it.
But Malas, it's unheard. Malas, will your lordship take up the application for a minute?
That politics which parties play.
It has nothing to do with politics.
We don't want to play
It has nothing to do with politics. It has nothing to do with politics, Malas. They cannot complete this exercise. They have only given notices to X number of people.
They will have to complete, and your state machine.
They can't, Malas.
Support. All the collectors.
They'll have to give notice. They have to give hearing to 9 lakh people every day to complete that exercise. And so far, they've only given hearing 1 lakh people, Malas.
This data is.
It's all the data is all there.
No.
Malas, therefore, he can file a reply by Monday and we can take it up, Malas.
Almost the date of objection is over, my lord. Today is 28th, 30th, it is getting over. If this is, the idea is,
in Tamil Nadu,
they will keep on moving applications so that we keep on extending.
No, we will not grant any further action. There is no question. Now, the otherwise it will become mockery of this system.
West Bengal is 30th, 7th, Malas, not tomorrow. It is Tamil Nadu which is tomorrow.
So, Tamil Nadu tomorrow?
Yes, that's
Great.
West Bengal is 7th, so you can have it on Monday, you can file his reply.
In Bengal also, last
can
date
file his
for
reply.
objection is 30th.
What?
Last date for objection in Bengal is also 30th.
No. I'm sorry. No.
The order
We have
itself.
provided everything at the doorstep. Even if they can't, we have all possible documents we have included.
May I request your lordships to look at the application, nothing more than that, Malas. 48. Just look at the application, we'll just demonstrate to your lords here.
Tuesday or Wednesday. Next.
Tuesday or Wednesday. Tuesday or Friday, all right. Tuesday.
Wednesday.
Let them file their reply in the meantime, Malas. At least that they can do.
It is their choice, Mr. Sipal. If you want to file letter, it's a matter of record.
All right. Very well.
Yes, Mr. Ansaria. 10 minutes, please. Free.
I will not be able to do, my lord, justice brief in 10 minutes time. Lord, I have a substantive writ petition, my lord.
Yes, sir.
I have a writ petition 634 of 2025.
All right, please quickly.
No, I'll do as quickly as
I
possible.
have to wind up this matter.
Your lordship,
Great amount of
kindly hear me, lordship. I am petitioner in person for item number 51, sir.
Which item?
Item number 51.
What was the item?
Yeah, it is related to the maintainability of writ petition. Actually, here is it.
आइटम का ना बड़ा शौक है जाके टीवी पर इस पे आए कि अब ये पता नहीं होता आपको कोई चीज मेंटेनेबल है कि नहीं है
No, sir. I in
लीगल एड कौन से दे देते हैं
you can provide, sir, but I in 2.5 year I have approached everyone, including Allahabad High Court, but I now I do not have any money.
all right we will give you some other date yes please
May I please, lordship? Lord, I have my written submissions with your lordship. Kindly take that.
My I'm so sorry, my lords. I have a small mentioning. May I please mention item 31? This is that representation of women in Bar Council election matter. My lords, on Friday, Telangana Bar Council elections are taking place. I just need 4.5 minutes of this court's time today or tomorrow, whenever it suits, my lords.
So what is the problem now?
We need a small clarification regarding the procedure for counting of votes. There is no clarification till now. We have approached the supervisory committee also.
Committee, we have constituted committee.
We have.
Committees are headed by former Supreme Court judge, former Chief Justice of the High Court. Please go there.
We have.
Don't disturb for smallest things to the.
My lords,
in court number 1, we will tell how the votes are to be counted.
my lords, we have.
Application take on record rejected.
My lords,
to approach the concerned committee.
My lords, we have approached them. We have not
Thank you
heard.
very much. These have become a fashion for moving applications one after the other. We are also fed up with this election. We will not entertain any application. Why we have constituted committees? Why don't you go there?
My lords, we have.
Is it a question of status that you don't go before retired judge? You start.
Yeah, may I please, lordship? With your
Your Lordships now take up my written submissions, my Lord. I have just handed over. My Lord, firstly, my Lord, my writ petition is seeking a mandamus. There should be regular SIR. And some of the pleadings, my Lord, I want to show to your Lordships, my Lord. I have quoted some of them, especially one paragraph, paragraph 9. There's a huge infiltration, my Lord. My Lord, your Lordships have, Mr. Naidu has pointed out what are the pleadings in the writ petition, my Lord, by Mr. Association for Democratic Reforms or otherwise, my Lord. In my case, my Lord, if your Lordship kindly take up the writ petition, my Lord, para 9. Specifically, I have said there are, Lord, it requires that there is a large scale infiltration, so to the extent of external aggression, Lord, under Article 355. And in the writ petition, my Lord, I have implemented Union of India, all the states as parties. Everybody has been served, except Election Commission. Nobody has filed any reply. The Election Commission says yes, we are. It is the SIR is like to be required to be conducted, my Lord. In para 8 of the counter affidavit of the Election Commission, my Lord, they say that yes, it is required and it is to be done. Now, my Lord, what is the constitutional mandate of 324? Mr. Dwivedi has taken to your Lordship, Lord. I don't want to repeat that. What is important is, my Lord, Article 289, Mr. Dwivedi has pointed out, draft article did not have the provision for, I'm so sorry. If you kindly give it. Article 289 draft article did not have the provision for revision of electoral roll, which was brought about by an amendment. I'm so sorry. If your Lordship kindly return submissions. Page 3 of my written submissions now, my Lord. Page 1 and 2, I pointed out, I've summarized, my Lord, what are my pleadings, given the relevant para numbers. And, my Lord, para 4, I have said what is the response of the Election Commission. Would your Lordship now kindly come to page 3, para 5. Now, 324, my Lord, it has been said, it is only the citizen of India who are entitled. And what is important in, my Lord, the speech of Dr. Ambedkar, my Lord, when he pointed out about the amendment of 289, which I have quoted, my Lord. And what is important is highlighted portion. The House will realize franchisee is the most fundamental thing in the democracy. And franchisee is only to the citizens, my Lord. And it is also says it is not only the preparation but also the revision of electoral roll. It is very specific and very clear, my Lord. With that, my Lord, para 8 I have said, it is submitted that the intensive revision of electoral roll is essential to ensure that the sovereign will of the citizens is expressed through the elected representative. It is submitted that only Indian citizens can be included in the electoral roll and all those who are ineligible to vote cannot be examined, must be excluded. Now, my Lord, what is important is, my Lord, if your Lordship kindly take up, my Lord, the Representation of People Act for a minute, my Lord, with me. Section 16 and 18. Would your Lordship kindly permit me to place that, my Lord? I have quoted it, my Lord, but section 16 says, my Lord, there are 3 requirements: not a citizen of India, disqualification, unsound mind, and disqualified from voting under provision of law. Lordship, what I am showing, my Lord, the argument is that all the 3 requires an adjudication by an outside authority. So far as 16A is concerned, it does not say. 16B and C says, my Lord, it requires an adjudication by an outside authority. Similarly, section 19, which I have quoted in page 6, my Lord, it does not require any adjudication. So, my Lord, there are 5 requirements for qualification or disqualification of being eligible to be in electoral roll. One is citizen of India. Second is unsound mind. Third thing, disqualified from under any law. Fourth is 18 years of age. And fifth is ordinary resident. For 3 requirements, my Lord, in para 13, I have said, there is no requirement of, my Lord, any outside authority to say. For example, for citizen of India, it is the, my Lord, the Election Commission decides. Whether he is above 18 years or below 18 years, Election Commission decides. And, my Lord, whether he is the ordinary resident, his Election Commission decides. And, my Lord, he decided for the particular purpose. It is not, my Lord, the universal declaration, as has been argued, my Lord, it has been said. So there is a, my Lord, very important distinction under the statute, 16 and 19. In 16 clauses A, B and C, A does not require any adjudication by outside authority. B and C requires an adjudication by the others, by an authority, my Lord. That is what I have said in para 13 of my written submissions. Now, my Lord, another important thing is regarding verification of citizenship. Now, my Lord, verification of citizenship is not only under the Representation of People Act. If your Lordship kindly see page 7, my Lord, at least 10 other statutes, the benefits are available only to the citizens. For example, under the Advocates Act. Lord, all these provisions I have given at page 22 in Schedule 1. If your Lordship kindly see for a minute, my Lord, page 22. For a minute, my Lord.
Page 22.
Page 22 of this, which are the relevant statutory provisions, my lord. For example, under the Advocates Act, to be enrolled, he must be a citizen of India. Under the Patent Act, to get a patent, he must be a citizen of India. Under the trademark rules, it must be a citizen. Under the Army Act, etc., etc. And what is important is page 23, Roman 9. Under the RTI also, he must be a citizen of India. So, my lord, if an RTI application is made by a non-citizen, can the my lord, PIO not say, no, you are not a citizen of India, and my lord, so we will not entertain your application? Does it require an adjudication, my lord? He is to wait for an adjudication, the PIO, my lord. So, my lord, if your lordship has to say the citizen of India is to be determined only by the central government under the Citizenship Act or by the Foreigners Tribunal under the Foreigners Act, my lord, then all these allegations, that law will be applied, my lord. Even the passport authority cannot decide. Even the Bar Council cannot decide.
So we understood that verification of citizenship
Yes,
is
Lord.
not an adjudication.
Is not an, and there are similar several laws, my lord, which requires a verification by the authorities other than, my lord, the central government or the Foreigners Tribunal. For example, what I have said in para 7, last column, which are the authority which required to verify the citizenship for getting benefit under those statutes, my lord. And those statutes I have quoted at page 23-24. Now, my lord, another important thing is page 8. Citizenship Act, as originally enacted, section 3 gave right to citizenship by birth. Now, what is important is, my lord, page 8, para 17, I have quoted this section 3 as originally enacted, which says every person born in India on or after 26 January shall be citizen of India. Now, my lord, the parliament found that there is a gross, my lord, if I can read, this is very important, para 18. Section 3 of the amendment was amended by the Citizenship Amendment Act 1986. The objection regions of the said amendment was substituted in section 3 by thus: objection regions, a large number of persons of Indian origin have entered into the territory of India from Bangladesh, Sri Lanka and some African countries, and they are residing in India. Government has taken a serious view of the entry of the persons clandestinely into the India, and with a view to making provisions of the Citizenship Act relating to the grant of Indian citizenship more stringent, it is proposed to make inter alia the following provision, and section 3 has been quoted, now, my lord, amended, which requires you have to be born and either of whose parents are citizen of India by birth. So by birth is not sufficient because, and the parliament has taken this, my lord, conscious decision that there is a clandestine entry of for illegal foreigners of a huge number, and that is the purpose, my lord, for amendment of the Citizenship Act. Similarly, thereafter, in 2004, it was made more stringent, my lord, which I have quoted in paras 19, page 9, the objection regions, and my lord, after making this highlighted portion, to prevent illegal migrants from becoming eligible for Indian citizen. And then not section 3 is quoted after amendment, which requires that even if one of the parents is illegal migrant, my lord, he will not be a citizenship by birth. So, my lord, the parliament is consciously, my lord, I put the table at page 10, para 20. There are 3 categories of persons, my lord, by birth. Firstly, from between 1950 to 87, born in India is sufficient. Between 87 to 2004, born in India plus either of the parents is citizen. And after 2004, my lord, born in India, both parents, or if one parent is a citizen, the other must not be an illegal migrant. So, my lord, the parliament, now, my lord, para 21, if I can read, my lord. It is submitted that since 3/12/2004, even if one of the parents of citizen of a person who is born in India is an illegal migrant, he or she is not entitled to citizenship by birth. The provisions regarding denial of citizenship by birth to a person either whose parents is an illegal migrant has been made having regard to the large number of such illegal migrants in the country. It is therefore the constitutional legal duty of the Election Commission of India to ensure that citizens alone are in the electoral roll, since franchisee is the most fundamental thing in democracy, as stated by Dr. Ambedkar in the Constituent Assembly. Now, my lord, next limb of my argument is, my lord, having regard to such illegal migrant, to such proportion, what is the duty of the statutory authorities, my lord, and the constitutional bodies? That is what Article 355 says, my lord, which I have quoted. it shall be the duty of the union to protect every state against external aggression and internal disturbance, to ensure that the government of every state is carried on in accordance with the provisions of the constitution. It is stated that India has a massive illegal migration from the neighboring countries, especially after Indo-Pak War and the creation of Bangladesh. Such huge influx of illegal migrants is a matter of record and has been so stated by the government of India from time to time. The petitioner crave leave to refer to the following statement. Indrajit Gupta in 1997 says it, my lord, there are 10 million, 1 out of 10 is an illegal migrant. Then there is a governor report of Assam, my lord, which has said it has changed the demography. Then again, my lord, the Home Minister in 2004 says there are 50 lakh illegal Bangladeshis in Assam and 57 in West Bengal. Then again in 2016 say that 2 crore illegal migrants, my lord. With regard to, if your lordship count permit me to read para 24, page 13. It is submitted that the extent of illegal migrant in Assam are to the extent that the same amounts to external aggression under Article 355 of the Constitution, and it is the duty of every organ of the state to prevent such aggression. Having regard to the huge number of illegal migrants in the country, it is the bounden duty of the Election Commission to ensure that none of these illegal migrants get the voting right and their names are removed from the electoral roll if wrongfully entered. Now, it is submitted Article 355 of the states that it is the bounden duty of the state to protect every state from external aggression and internal difference. The later part of Article 355 is of much importance, as it says that the government of every state has to be carried out in accordance with the provisions of the Constitution. For a government to be carried on in accordance with provisions of the Constitution, it is incumbent that such a government must be elected by eligible voters, and the duty is to prepare an electoral roll of eligible voters is vested in the Election Commission. The sacrosanct nature of the election has to be prepared by the Election Commission of India by conducting SIR of the electoral roll from time to time. Otherwise, the democratic process will be subverted and the government will be elected by the non-citizens and infiltrators. Now, my lord, I have quoted Sarbananda Sonwal, my lord, Mr. Everybody has referred to it. Now, my lord, what is important is para 27. Now, my lord, all the 3 limbs of the state, that is, my lord, the parliament while enacting the Citizenship Act, the executive making various statements, and the judiciary, my lord, in the Sarbananda Sonwal case, has found that there is a huge influx of illegal migrants in the country. Lord, this is a rare combination where the parliament, executive and judiciary has said, my lord, there is a huge infiltration. And this, my lord, if they are in the electoral roll, my lord, then the parliamentarians reflect the will of the people, not of the will of the citizens, my lord, will of the foreigners, my lord. Now, my lord, this having been done, my lord, in my respectful submission, the exercise which is being done by the Election Commission is definitely necessary, and it is mandated, my lord, by the constitutional scheme of the containing the Article 324 to 326 and also in the RP Act. Now, my lord, one of the last limb of my argument is, my lord, your lordship has made Aadhaar as a part of, my lord, the documents relevant by an interim order. Lord, I want to show to your lordship 3 or 4 provisions of the Aadhaar Act, my lord, that it cannot be done, my lord, in my respectful submission. Now, my lord, I have quoted it, the Aadhaar provision, Aadhaar, my lord, page 15, if your lordship kindly see, my lord, the objects and reasons of Aadhaar is an act to provide as a good governance, efficient, transparent and targeted delivery of subsidies, benefit and services. So this was the purpose, my lord. And section 2(5) defines resident. Resident means an individual who is resided in India for a period amounting to, in all, to 182 days or more in 12 months immediately. Anybody who is in India, a foreigner, I will demonstrate that, is entitled to Aadhaar. Now, section 3 mandates that every resident means if you are in India for 182 days, shall be entitled to obtain Aadhaar number by submitting in demographic information, biometric information, by undergoing the process of enrollment, provided the central government may from time to time notify such other category of persons who may be entitled. Now, section 9 says Aadhaar, now this is very important, my lord, Aadhaar number or authentication thereof shall not by itself confer any right or proof of citizenship or domicile in respect of Aadhaar number holder. Now, Lord, may I pause here, my lord? Why did the Election Commission, my lord, require the documents for 3 things? For citizenship, for age, and for ordinary resident. Now, my lord, the mandate of Aadhaar Act is you cannot use it for citizenship, you cannot use it for domicile purposes. Now, what remains is, my lord, the date of birth. Now, my lord, so far the date of birth, now lordship has, my lord, made a reference of section 23(4) of the RP Act for making Aadhaar as a relevant document. Now, would your lordship kindly see, my lord, what is the object? It was inserted by an amendment in 2021. I have put, my lord, the objects and regions in para 31. Would your lordship just excuse me for a minute?
Yes.
The objection region says the amendment of section 23 enabling for linking of electoral roll with Aadhaar ecosystem to curb the menace of multiple enrollment. This was the only purpose, my lord, for which 23(4) was inserted. And what does the 23(4) says, my lord, is, I have quoted it, inclusion of the names in electoral roll. Any electoral registration officer may, it is not, my lord, shall, for the purpose of establishing the identity of any person, require such person may furnish Aadhaar number given by the Aadhaar authority, provided that the election registration officer may also require Aadhaar from persons already included in the electoral roll for the purpose of authentication of entries and to identify registration of name of the same person in the electoral roll of more than one constituency. The whole purpose was, my lord, it has been found there are multiple entries. So if you have put the Aadhaar number, my lord, then it can, what purpose is to avoid, to identify the persons whose names are in more than one place in the electoral roll. So with Aadhaar, they can, my lord, identify that person. And that's the whole purpose of section 23(4). And it is in the light of, my lord, what the Aadhaar Act says in 2016, what the Amendment Act says in 2021, the objection regions, and the specific provision, my lord. It was never stipulated, my lord, that Aadhaar can be used for any of the three purposes for which, my lord, the electoral rolls are required to be submitted to the document, namely citizenship, namely the age of birth or date of birth, my lord, or for the purpose of, my lord, the domicile or the ordinary resident. Now, my lord, with that in mind, if your lordship kindly see, my lord, para 33, page 17, it is pertinent to note that the Aadhaar card is issued by privately run common service centers as per the Ministry of Information and Technology, Government of India, is in November 2025. A total number of 5,72,973 common service centers are functioning in the country. Any person who has passed 10 standard and has biometric computer knowledge can open the common service center, and I have given the page number. But so, not any person, 5,72,973 centers which are privately run, issues Aadhaar, and that becomes a relevant document, my lord. In my respectful submission, that cannot be the relevant document for the purpose. That's why, my lord, the Election Commission consciously, my lord, said that Aadhaar will not be a relevant document, but under your lordship's order, thereafter it has been added as a document, my lord. I am requesting your lordship, my lord, to reconsider that order. Now, second, my lord, it is submitted a document issued by a privately run center cannot be relied upon for the purpose of electoral roll. It is pertinent to note that as per the UID report on saturation of percentage of Aadhaar has beyond 100% in certain states. Document which,
You know, your passport is also outsourced to a privately run.
no, the passport is,
Your passport is also
there, my lord.
outsourced to a privately run agency under the auspices of the government of India.
Please, your lordship.
Then
No, passport is not, no, what I'm saying, my lord.
operating under the statutory authorities or the government itself.
No, my lord, but here they are, my lord, you don't require any
Card is a public document.
Yes, my lord. But it does not require any authentic, my lord. He goes with a certificate from a my lord, partial from a municipal corporator or municipal authorities, my lord, and a municipal corporator, and he gets Aadhaar, my lord. It does not, 5,72,000, all other documents which are mentioned in item 1 to 11, my lord, they are not issued by any.
None of them can be forged, only Aadhaar can be forged.
No, I'm not forging, I'm not forgery part of it. My lord,
The bank record cannot be forged.
no, my lord, I'm not saying on the forgery, my lord, it's a completely different thing.
So that is.
No, I'm not saying forgery, my lord. I'm saying.
Mr. Hansalia, if you argue that an Aadhaar card can always be a forged document and it is within the scope of the ERO to verify the authentication.
No, I'm not saying, my lord, I'm saying a common service center, a privately run person, an individual issues Aadhaar card, my lord. Whether that can be by mandamus, your lordship would say that will be treated as a relevant document.
The issuance of the Aadhaar cards,
Yes.
sir, that private individual discharges a public duty.
No, lord, but is there any control, my lord? What he does is.
Yes, there is
No,
a control.
no, what he does is, my lord, he gets a certificate from a municipal corporator or a panchayat person, my lord, and he issues the Aadhaar, my lord.
So
I'm not saying it is a force. I'm saying it is issued, my lord, by genuinely by a person, but a person, an individual who is issuing the Aadhaar, can it be, my lord, under the statutory scheme?
It is. Unfortunately, it is.
My lord, if let's say lordships to consider, my lord.
Don't advance that argument. That argument is
No. My lord,
meant to be rejected.
no, my lord, what I'm saying, if your lordship see the Aadhaar Act,
They followed you.
no, my lord, lordship, all that.
Follow your submission.
Yes, my lord, I'm grateful to your lordship.
Go ahead.
All that I'm saying, my lord, section 9 specifically excludes Aadhaar for the purpose of citizenship and domicile. If a Aadhaar which is issued under statute said you cannot use it.
This court never said that include Aadhaar
Yes, my lord.
to prove citizenship.
Your lordship,
It said that Aadhaar is a acknowledged document of identity
my lord.
as per the statutory scheme of the Representation of People's Act.
Yes, my lord.
And if that is so, then the enumeration would ordinarily take into consideration
My lord.
the scheme of the Act and include Aadhaar. And
Lord,
that is the foundation of our order.
My respectful submission, scheme of the Act says it is to avoid duplication, my lord. That was the purpose of making the Aadhaar, not a relevant document to
Perhaps,
include.
Mr. Hansaria, you should go back to the SIR recitals.
Yes,
One of the ground of SIR to be undertaken is duplication.
yes, my lord.
So,
No, Aadhaar number is
while
given.
there is a
Aadhaar-
reasonable nexus between Aadhaar identity
Yes.
and the object that special revision is serving, namely dead, multiple entries, migration.
Yes.
Multiple entry
Yes.
can only be eliminated
Yes.
through identity of the
Your
individual,
lordships.
where Aadhaar, even by your
Yes.
interpretation of
yes.
the document,
Yes.
is acknowledged as a proof of identity.
Yes.
So that
My lord, the
document,
limited.
in our understanding,
Please, your lordship.
had a clear
Yes, my lord. Your lordship will.
a nexus with
Yes.
the
Lordship-
purpose which the
I'm great.
commission is seeking to achieve through this special revision.
Yes.
Right? Nobody at any point of time argued, or it was in the contemplation of the court, that Aadhaar is a proof of citizenship.
Yes,
In fact, what was argued
No.
is
Yes.
something different.
Yes, my lord.
That look at the 11 documents.
Yes.
Can land record be proof of citizenship?
Yes,
But that document is there.
my lord.
Why? So these 11 documents need not always be a clear relation to citizenship, but they may be of various species,
Please, your lordship.
which would ordinarily relate to what? The purpose which the Election Commission seeks to serve
My lord.
in exercising its plenary powers.
My-
That has been argued by Mr. Dwivedi,
Yes.
Mr. Singh and others
Yes.
under Article 324, articulated through the statutory scheme under 21 subsection 3.
I'm grateful, my lord. Yes. Yes.
So your argument actually is going cross purposes with the Election Commission's view that Aadhaar is not at all a document to be considered because a private entity is preparing the document. Even if a private entity prepares a document, but if it is statutorily acknowledged as a proof of identity under the Representation of People's Act, the Election Commission would naturally know.
I'm grateful to your lordship for the query, my lord. May I answer, my lord? Those 11 documents are all issued by the government authorities, my lord. Here it is a private individual with 10 standard and 5 lakh and odd 6 lakh persons who are issuing, my lord. And the election commission did not say, my lord, we will do it. Under your lordship's order, election has been done. A mandamus has been sought. Has any foundation been laid, my lord, in any of the writ petitions, my lord? I have checked, my lord, all the writ petitions. The plea is, the prayer is, my lord, to struck down the Bihar SIR or, my lord, others SR activities. Not that a mandamus may be given that Aadhaar include an Aadhaar. So without a pleading in that regard, my lord, would your lordship issue a mandamus, my lord? That is, my lord, my respectful submission. And especially when the saturation point is beyond 100%. In many states, 106% documents are there, my lord, saturation point. Then it can be, whether it can be done or not, lordship would kindly consider it, my lord. And I have given, my lord, that, so 3 things, my lord, 2 things, Aadhaar Act itself says it cannot be done. For the date of birth, my lord, there is a judgment of your lordship's court and followed by upholding the Maharashtra, Bombay High Court, plus Aadhaar cannot be a proof of date of birth. For all the 3 things, my lord, you request citizenship or domicile or the proof of birth, it cannot be used. That's my respectful submission. Lordship would consider it, my lord. It is only for the limited purpose of controlling the duplications, my lord. That's my respectful submission. The proviso makes it very clear. Now, my lord, a submission has been made My lord, I have put about the Aadhaar, my lord, other paragraph 36 to 41. I don't want to repeat that, my lord. Now, my lord, last submission which has been done is, my lord, it has been done, my lord, as if, my lord, the SR activity has been done to favor a political party, my lord, which has been submitted. Now, I have shown to your lordship, my lord, so far Bihar is concerned, my lord, if your lordship finally come to page 20, para 42, the difference between the deletion, SR deletion and margin of votes has been more, my lord. The SR deletion is more than the margin of votes, and it is across party lines. Across party lines have won because of this. So it cannot be said, my lord, Aadhaar has been, that is what has been the slogan all over. Aadhaar has been made, my lord, or SIR has been conducted to favor a political party, which is, my lord, is on the face of it, page 20, my lord. Every political party have won because of the difference, my lord, in the deletion of the SIR, my lord. That's my dispute. That cannot be imputed a motive, my lord, to the Election Commission of India. And finally, my lord, page 21, I have concluded submissions, my lord. SIR is indispensable for preserving the integrity and democracy and ensuring elections reflect the will of the people and not foreigners. Large-scale infiltration of migrants is an act of external aggression and internal disturbance within the meaning of Article 355, altering the demography, distorting representation, burdening public resources, fueling organized crime, promoting radicalization, contaminating the electoral process by enabling non-citizens to fabricate documents and enter electoral roll. When these are not citizens, influence the electoral outcome, the promise of Article 326 that universal adult suffrage belongs exclusively in Indian citizens is defeated. This honorable court may uphold the exercise of SIR in Bihar and other states, my lord, and the order dated 8-9 regarding Aadhaar may be modified. My lord, that's my respectful submission. If your lordship kindly see, my lord, page 29, my lord, where the Aadhaar is issued to the foreigners. If there are, in the Aadhaar, my lord, if your lordship see Aadhaar 29, page 29 of the submission, where it says, my lord, document which is issued to foreigners, page 29 at para 30, 32, 32 and 36.
That Mr. Ansari, you already read the definition of resident.
Yes, my lord.
So it is clear from there.
Lord, that's why it further goes, my lord. The document itself says, page 29, Aadhaar is a proof of identity, not of citizenship, address or date of birth. If the document itself says, my lord, and these are the three purposes which is required for SIR, either citizenship or ordinary resident or date of birth. There is no fourth reason, my lord.
Multiplication?
My lord, citizenship,
multiplication number increase.
Yes,
your
multiplication, that is the
SR which has been undertaken.
My lord, yes.
The affidavits filed by the Election Commission has three categories. One is dead,
my lord.
One is missing,
my lord.
And one is duplication.
Duplication, yes.
Tell me, Mr. Ansari.
Yes, my lord.
What is duplication?
It is,
and for that, identity of the elector entered in the electoral roll is necessary to be verified.
It is necessary, my lord. If a lordship says it is avoid duplication,
what is there, sir?
My lord, I'm so sorry.
You are inventing a fourth ground.
Yes, my lord.
Namely citizenship.
Yes.
And you are creating the fourth ground of citizenship and thereby debunking a document.
Yes. What I'm saying,
can you do that? You have to identify, it's not your brief at all.
Yes.
To support or to criticize the.
Yes, my lord.
Your writ petition is very different.
Yes, my lord.
Your writ petition is SR should be
regularly conducted, not after 20 years, my lord, as it's been done now.
Correct.
And which is being vigorously opposed.
Correct.
Yes. So for avoid duplication, if a lordship clarify, that is for the limited purpose.
Now see the difference and why Mr. Dwivedi filed the affidavit.
Yes.
Saying that we would do it. Definitely we will do it.
My lord.
You have founded your requirement of SR essentially on illegal migration.
My lord.
Correct?
Yes, my lord.
Entry, border entry, etc. Show us one word,
my lord,
illegal migration,
my lord,
in the SR which is before us in judicial review.
My lord.
If that illegal migration not existed,
my lord,
inferential otherwise will come later on. But in clear words, there is no illegal migration. So you are creating a requirement for SR for illegal migration, and the Election Commission says yes, definitely we will do it.
No, my lord.
So what is the conflict?
my lord, I don't go more than that, my lord. It is under your lordship's order to avoid, my lord, so that there is no duplication. And illegal migrants is, my lord.
Our order is not in your writ petition.
No, it is.
Our order
Yes,
is
your lord.
in an SR.
Yes, my lord, SR.
Which is challenged by this
There's no,
petitioner.
no, it's not. It is a hearing together.
It may be possible that in a SR which relates to illegal migration,
My lord.
verification of citizenship, you
Yes.
can say Aadhaar will not be a relevant document.
Yes.
Then our question will be, if you put that test, will land records be a relevant document?
No, land record would be, my lord, because
Will
they are issued by
relevant
government
for citizenship.
authorities. They are issued by the STM, my lord, not by individuals, my lord. Well, anyway, my lord, I don't want to trouble your lordship with more than that. I have submitted, my lord. I just wanted to show, my lord, the Aadhaar can be used and is used to issue foreigners also. A document which is used to foreigners also, my lord, cannot be used. That's my respectful submission. Lordship would consider that, my lord. I think I'm extremely grateful to you.
Thank you, Mr. Chair. Yes, Mr.
Yeah, we just, my lords, prepared some written submissions, but your lordships have heard it long enough, so I'm not going to take too much time. If your lordships will permit me, my lords, without those submissions, let's just look at Article 324 and 326, my lords, before we look at this. Because much emphasis has been laid on these articles. My lords, nobody can dispute that the entire process of election is under the control of the Election Commission. Nobody can dispute, nobody should dispute. It's a constitutional obligation. The question is not that, my lords. The question is how transparent is that control? That's the question. How is it a rule-based control? Is it a rule-based procedure? Because every act, ultimately, this is not a judicial order, my lords, it's an administrative act. Every administrative act must be based on reason. So as far as 324 is concerned, we have no problems. We're challenging the procedure through which all this has been done. We'll come to that a little later. Now, my lords, kindly come to 326. And I'll read it, my lords, with your lordship's permission. The election to the House of the People and to the Legislative Assembly of every state shall be on the basis of adult suffrage. That is to say, every person who is a citizen of India, just mark those words, who is a citizen of India and who is not less than 18 years of age, on such day as may be fixed in that behalf, by or under the law, any law made by the appropriate legislature, and is not otherwise disqualified under this constitution. Mark those words. And is not otherwise disqualified under this constitution, or any law made by the appropriate legislature, on the ground of non-residence, unsoundness of mind, crime or corrupt or illegal practice, shall be entitled to be registered as a voter at any such election. Only those four grounds. And is not otherwise disqualified. And how is he otherwise disqualified, Mullahs? That he is not a citizen of India. Now you will find that in just, Mullahs, now look at section 16 of the Act. This will give you an idea as to what the purpose is. I was looking at the Constitution, and of course, entry 17 of list 1, citizenship is under entry 17 of list 1. Entry 17 of list 1. But I was looking at the rules of business, Mullahs. I just hand them over to your lordships. And under the rules of business, it is the Ministry of Home Affairs, Department of Internal Security, which deals with issues of citizenship. You will see at page, it's at the bottom, page 104. The heading is Ministry of Home Affairs, Department of Internal Security. Your lordship has that? And let's just go over the page, Malad, and kindly come to 56. Entry 56, small o. And you will find Citizenship Act.
No, earlier you referred entry 17.
Entry
List
17.
one. So-
Entry 17, list 1,
Neutralization and alien.
correlated with list of business.
Yes, sir. Let's go to the last.
Kindly see entry 22. Well, let's kindly see entry 22, sorry.
Page number was extracted.
At the bottom, your lordships will find at page 105, just on top of that, entry 22, grant of Indian citizenship by registration and naturalization. So the entire field is occupied under the Constitution under the authority of the central government. Now, having said that, now look at read 326 is otherwise disqualified under the Constitution with section 16. And you'll get the answer. So I don't think we need too much time on this. 16 says a person shall be disqualified for registration in an electoral roll if he is not a citizen of India. The word not is there. Now, who decides that a person is not a citizen of India? The government of India. If I am born a citizen of India, Mullad's between the coming of the Republic as well as Mullad's 1987, there is no issue. From 1987 to 2003, there is no issue as long as one of my parents is a citizen of India. Normally, if somebody says one of your parents is not a citizen, let's say that. Who is going to decide that? Can't be decided by the commission because the power to grant something includes the power to withdraw it. It's as simple as that, Mullahs. But somebody can question it, which is why you come to Form 7. And Form 7 says you can question my citizenship.
Then who decides, Mr. Singh?
Then I'm telling you, Lord, then he has to give proof.
No, that's another, that's the.
No, but it says without that he can't. Without he can't, he'll be prosecuted.
Form 7, someone questions my citizenship.
Yes.
In such situation, who decides? Central government or the ECS?
Central government, obviously, Mullah. It's the central government which can decide because my citizenship can't be taken away. That's why not disqualified.
To ERO in all probability.
I'm sorry?
The Section 7 dispute will be decided by ERO.
No. Well, I'm sorry, no. Let's read Form 7. Wait a minute. That's not correct. I may be wrong, but let's.
Right to be enforced.
That's right. Now see on Form 7. Have a look. See that, Mills? It says objection. I am not an Indian citizen. Your Lordship sees that. Then he says item number 2, objection and application for deletion. And the onus of proof to substantiate the reason given for objection or removal of the name lies with the applicant.
Sir, you are absolutely right. These are the procedures and the owners. Who is to decide?
I'm just coming to that, Mills. I'm just coming.
ERO.
1 second, Mills. Just let me correct, Mills. Now, that means, Mills, if the ERO decides, let's assume my Lord is what my Lord is saying is right.
See Section 62 of the RP Act.
Yes.
Two things.
Yes.
We have two threshold two clause. One, it's citizens of India, but all citizens of India are not eligible to vote.
Yes.
They must have their name entered in the electoral roll.
Correct.
Now let us say someone has a name entered in the electoral roll, someone disputes the citizenship.
Right.
Matter goes to the ECI or a representative
Let's assume.
of ECI
Yes.
who decides the issue
Correct.
to strike him of the role.
Right.
In such a situation, the person aggrieved can take it under section 9 before the Citizenship Act and say, get a declaration that I am a citizen. Thereby he gets again back into the role.
Now, let me,
We have understood Mr. Dwivedi's.
let me, that's why I was trying to respond to that, Mullah.
Yes, sir.
I was trying to respond.
Why we
I have to respond to that.
clarity, because
Now he says, Mullah, let me see, Mullah, I'll assume
it's a clear idea.
I'll assume for the moment, Mullah, that the ERO can decide. So on that day, I lose my right as citizen?
No, you lose your right to be in
In the electoral roll? Right. Fine, Mullah. I lose my right to be in the electoral roll because according to him, I am not a citizen.
Let's consider a situation. A passport has been issued, but
Yeah.
the passport is patently a forged document.
Yes,
An objection is made in
correct,
HONBLE,
correct.
goes to the ER.
Yes,
ERO says, my God, this is not at all a passport, and as Mr. Hanaria says that
correct.
there is possibility of forgery.
Right.
So it's a forged document.
Right.
We strike you off the road.
Right.
You have to go immediately to the central government. Get a declaration, no, I am a citizen.
But-
And again, get yourself back.
Therefore, Mullah, prima facie, for my name to be included in the electoral roll, that's what my lord is putting to me, the ERO has the right to decide that I am not a citizen of India. For the purposes of excluding,
From the roll.
I'm saying that, Mullah, I'm saying exactly what my lord is. I'm saying,
Actually, we also had a confusion over this, which is why we put a question to Mr. Dwivedi that can such a vital right be taken away when citizenship, ultimate adjudication lies under the Citizenship Act with the central government? And there his answer was, since the constitutional power of preparation of law rests with the Election Commission, it would definitely have plenary power over the statutory right of determination.
that's why I read 326, Mullah. That's why I read 326. It says not otherwise disqualified under the Constitution. And otherwise disqualified under the Constitution is under the Citizenship Act. Mullah, just let me answer that question. Mullah, what will the ERO ask me if I am born, Mullah, if I am born between 1950 and 1987? If I'm on the electoral roll, ERO can't, Mullah, question that. If I don't have a birth certificate, will he say, you don't have a birth certificate, you are prima facie, I'll remove you from the electoral roll?
That may be wrong.
I'm just saying, Mullah.
Wrong.
Mullah,
Because there are two aspects.
Yes.
One is the existence of the power, another is the exercise of the power.
yes, that's correct.
Now, the existence of the power may be there, but the exercise may be arbitrary,
No, therefore,
uninformed, or as
I'm coming to that only, Mullah.
the Honorable Chief Justice indicated earlier, that it cannot be unbridled. There must be transparency and accountability of every power, howsoever high and
So
constitutional.
therefore, your lordships is assuming that one, there is existence of power because the election commission is preparing the electoral roll. And as long as the existence of power is there, he is prima facie, he can remove you from the roll and you have to go up and appeal. So, Mullah, I'm trying to answer that question. How is that power, according to me, doesn't exist, Mullah? So, number one, he will say that, look, I don't have a birth certificate, millions of people don't have. Prima facie, you are not a citizen of India, and I'll remove you from it. So, everybody has to go up and appeal. Mullah, that's number one. That's exercise of power. Secondly, Mullah, under the Constitution, if I am born between 1950, I am a citizen, Mullah. Between 1987 and 2003, one of my parents, Mullah, does the electoral ERO, will he ask me now, you show proof of citizenship of your parents, one of your parents, before I'll...
At least in this SR, they are not.
I'm sorry?
In this SR, they are not asking you to do.
No, I'm just saying, Mullah, I'm
saying that pre-2002, one of the parent in the electoral roll, you need not put in the documents.
Yes.
I'm sorry, just on a factual point, this SIR, they are asking for those after 2003 on the Bihar rolls, they are
Yes, yes, they
asking
are
for the
asking.
parents' documents. After
No, no, they are
2000
asking, Manoj. After 2004.
After 2002,
They are asking,
electoral
Manoj.
anyone's parent in that role, they are not going for.
They are, Manoj, with respect to
The only exceptions have been not Bihar, because we are looking at Bihar. Bihar, there was no question of logical discrepancy and
there, of course, of course.
that is different cases.
The only document they are asking is only to correct you with the electoral roll of your parents which you are relying upon. That
No, Manoj, there the problem is much worse, Manoj.
if you bring the electoral roll where suppose A and B are shown as husband and wife, and somebody say that they are my parents, so obviously necessary that much linking document will have to be produced that they are you are actually
To prove parentage, Manoj, there is no issue on that. There is no issue on that. Manoj, the problem that arises is in the procedure that is being followed. There will be very rare cases where somebody's citizenship will be questioned. Very, very rare. But here it's happening on a daily basis. Everybody, 1.82 crore people. We are citizenship being questioned. On what is the basis for that? I mean, you may exercise your power and bond.
Well, in Bihar, after this note of hue and cry of 65 lakhs, how many persons are found?
Manoj, how many illegal migrants were found in Bihar, Manoj, where all the exercise was done? Not one. How many illegal migrants?
So therefore, the initial apprehension ultimately may not prove to be correct.
No, Manoj, I am sorry.
It is in a case, if the facts and figure were that lakhs and lakhs have been declared illegal.
The number of people that were added, Manoj, we still don't know.
No, added is.
We don't even have the data with us, Manoj, the number of people that were added. Point is, Manoj, first of all, Manoj, let's forget about this case. A process of this nature should have an application of mind giving reasons as to why this has become necessary today. Why it's this necessary not for part of a constituency under 21(3), not for the whole of that constituency, but for the entire country. There must be some data, Manoj. After all, an election commission is a body under 324. It's a constitutional body. It should have enough data to demonstrate to the court, this is what we have found, this is our study, and therefore this has become necessary. Is there anything placed before your lordships on that? Nothing. And that we need to exercise this power, not only to a part of a constituency, not only to a one constituency, but all of India.
And one of the reasons
Yes.
for the SR, the way we read it, is migration.
Yes.
Then it requires multiple constituency verification simultaneously.
Right. No, I agree with that. Well, we are not disputing.
You cannot deny the fact that there has been an outward migration continuously in many states, including
The correction of the electoral roll is one thing, Manoj, but deletion of names is quite another. You can have mass deletions in this fashion. Mass deletions.
So simple correction is inherently deletion and addition are essential part of correction. If 2003 is your basis and in 2025, are we not ready to recognize that many have died, many have migrated, many have left the country, many have shifted to other places?
But Manoj,
are they bound to be deleted?
You're right.
Those were born and those were minor at that time in 2003 and have attained majority. They are bound to be included.
I agree.
So addition and deletion both are.
But that's updation already done. That this is an exercise that the Election Commission has done on a yearly basis. They must then tell your lordships, despite the fact
that argument is already there by you.
That updation is done year by year, so the 2025 list has all that. Despite that, if they still need a wholesale special intensive revision, they must place before your lordships the decision of the commission. No decision of the commission has been placed before your lordships. Then they must place before your lordships data that despite the fact that we have updated it year on year till 2025, This is not an exercise that their officials have done, which is not an exercise that's acceptable by us, even though it was done by us, and therefore we need it. Has anybody told your lordships that? So the point I'm making is, Mullahs, we're trying to do something, and then you are doing it in the midst of an election. Mullahs, not that I'm attributing any malafide to anybody. We're doing it in the midst of the election process. And we are asking this court day after day, this has happened, Mullahs. Now, for example, it will come again on Monday or Tuesday, whenever your takes are. They have given instructions, don't accept the Aadhaar card. They have given instructions in writing. Don't accept the Aadhaar card. They are getting, Mullahs, Government of India, public sector company, CEOs to oversee all this. Unrelated to any rule. Now the question is, Mullahs, if such an enormous exercise is to be done, it must be done fairly, transparently, and in time. Surely, Mullahs, your election commission is expected to do that. So I'm not disputing the fact that somebody may doubt my citizenship. Mullahs, it is not our case that every person on the electoral roll is a citizen of India and his citizenship cannot be doubted. No, this is not our case. All that I am saying is you can doubt it, but then you must have reasons which are germane to the Citizenship Act. What are those reasons? You were not born. Normally, if I can't have my certificate, he can't throw me out like that. He can't delete my name. Number two, that one of my parents was not born. So I have to get my parents' certificate. Where will I get it from? I don't have my parents' certificate today. I don't even have mine. Luckily, I have a passport. So I have one of those 11 documents. Then three, that one of my parents is an illegal migrant. Who is going to prove that, Mullahs? What is the kind of inquiry that is needed? I hope, Mullahs, I'm trying to convey the enormity of the exercise. How can any ERO decide that unless ERO has some evidence for each elector that one of his parents was an illegal migrant? It's impossible. And yet you are deleting crores of names. And Mullahs, I told your lordships at the beginning, this judgment of your lordships will actually decide the future of democracy in India. This is not some ordinary decision that your lordships are taking. These are not exercises that can be done overnight. These are not exercises that can be done few days before the election or 2 months before the election. And on an all-India basis. Exercise of executive power, administrative power must be based on reasons which are germane to that power. Not, the whole argument is we are Election Commission of India. Why would we do anything wrong? You must trust us ultimately. Somebody has to trust us. I'm not disputing that. But why was this exercise not done earlier? Much before the elections were to take place. Why, for example, the UP election is being done, with the exercise being done today? So these are all very, very serious issues, Mullahs. So you may doubt it. You may doubt it, but that doubt must be based on the reason which is germane to the Citizenship Act. One of your parents is an illegal migrant. None of your parents were born in India. You were not born in India. These are the three. What other reason can they give? The reasons can't be outside the Citizenship Act.
Yes, next question. Probability value.
Right. And then, 21.3, your lordships, that argument has already been made, that is an exercise that is to be done in particular exigencies and special circumstances. Right, Mullahs? So, and that's why, now come to 16, if your lordships don't mind, of the Act. It's here. That is, a person shall be disqualified. Now, the word disqualified is used, Mullahs, in 326. If he is otherwise not disqualified under the Constitution. So when you say otherwise not disqualified, here the word is a person shall be disqualified. So you have to read 324 in the context of for 16 in the context of 324, and he shall not be disqualified for registration in an electoral roll if he is not a citizen of India. So I will not be thrown out of the electoral roll. My Lord asked me this question. My name will not be deleted from the electoral roll unless it is decided that I am not a citizen of India. Your Lordship put me that question. That why can't I be removed from the electoral roll? 16 has the answer. It says, a person shall be disqualified for registration in an electoral roll if he is not a citizen of India. That decision cannot be by the ERO, according to me, Malas. And now read B and C together. If he is of unsound mind and stands so declared by a competent court. So can the ERO say that I think you are of unsound mind? Then is for the time being disqualified from voting under the provisions of any law relating to corrupt practices and other offences in connection with elections. Now again, a competent provisions of law. So B applies a competent authority, C a competent authority, A competent authority. What your Lordships is saying is, no, you don't need a competent authority for A, but you need it for B and C. With the greatest respect, Millet, 16 must not be read like that. What they are arguing is this is what they are saying. As far as A is concerned, well, nobody, if I am disqualified for corrupt practices, Millet, there will be an order of the commission. That will be on the basis of which my name will be. It says, no, a person shall be disqualified for registration in an electoral roll. It's at that point in time that my name will be removed. My name can't be removed before. So in answer to my Lord's question, do they have the jurisdiction? My request to your Lordships is section 16 so read, they will not have the jurisdiction. And secondly, Malats, in any case, the procedure must only relate to the provisions of the Citizenship Act. That I have, as far as section 16 is concerned, I'm done. Now, Malats, kindly look at 19. Conditions for registration. This is Malats, conditions for disqualification, be removed from the register. This is conditions for registration. This is just the opposite. It says, subject to the foregoing provisions of this part, every person who is not less than 18 and is ordinarily resident. Citizenship is not included here. Why is it not included here, Malas? For the simple reason that if I was born, I am deemed to be a citizen. And that is shown under the Constitution itself, Malas. Section deemed to be a citizen. Your Lordships will remember, section 13. 11. Every person who is or is deemed to be a citizen of India under any of the foregoing provisions. So there's a deeming provision, Malas, of this part shall, subject to the provisions of any law that may be made by Parliament, continue to be such a citizen. So there has to be a law made by Parliament to take away my citizenship. And that's reflected in the provisions of the Constitution. That's the Citizenship Act itself. And then nothing in this foregoing provisions of this part shall derogate from the power of Parliament to make any provision with respect to acquisition and termination of citizenship. This act is, this electoral law, the power of 324 is not termination of citizenship. It is prepare an electoral roll. So according to us, according to me personally, the concept of the power to exercise the right to say that you are not a citizen of India is not vested in the Election Commission at all. He can doubt it, send it to the appropriate authority in the Government of India, and the Government of India can decide that, look, we believe that you're not a citizen, you give the entire proof to us. But he can't remove me from the roll because under 16 that can't be done unless I'm not a citizen of India. And that's a finality attached to it, Malas. Because if your Lordship puts to me that prima facie, there's no finality attached to that. The Act requires finality. So, Mullahs, that's on 16 and on 19. Now, Mullahs, kindly have a look at.
Anything else, Mr. Subba?
Yeah, sorry, Mullah?
Anything else?
5 minutes more, Mullah. 5 minutes.
Probably the next point is page 9, probity value.
Yes. Probative value of citizenship of electors already on the electoral roll and misreading of Lal Babu, Mullahs. Mullahs, Lal Babu, if your lordship looks at the beginning of the judgment, no, just show the beginning of the judgment. It's a complete.
Lal Babu has been read and misread both. now you need to us to read it.
Mullahs, I don't know who misread it and who read it, but Mullahs, what happened in Lal Babu was notices were given under 21A. And when notices were given under 21A, the Supreme Court said the following, that you want to delete somebody's notices is for the purpose of deletion. If you want to delete somebody's name, you can't do it unless you follow that procedure. You've read it time and again, Mullahs. So therefore, to distinguish, Mullahs, Lal Babu in this fashion, Mullahs, is just a sleight of hand, Mullahs. That's all that I can say. And then, Mullahs, there's a Constitution Bench judgment that supports that view, Mullahs.
That Indrajit Barua.
That Indrajit Barua.
Yes.
That's ECR, that's 1985 4 SCC. Right. And Mullahs, your lordships have been asking. Your lordships have been asking the question as to why nobody has complained. Has been, my Lord Justice Bagchi has been asking that question. But quite frankly, once the election is over, who complains? Nobody complains. I mean, that's the practical way of it.
So much for a valuable right.
That's the people then get, you believe that this is your fate, there's nothing more that I can do about it. And lakhs and lakhs of people, Mullahs, just give up. But that's what I said, Mullahs, what your lordships will lay down, and I emphasize it again.
That is the gradient between political right and economic right.
That's true.
You take away the Aadhaar, people would have complained.
Yeah.
You take away the political rights, people are happy they have the Aadhaar.
That's true. That's true.
Sir?
One thing is very important.
Yes.
The senior has said.
One second.
And that's exactly my view.
Right.
Every 5 years.
No. Every 5 years means that every election, I guess. Anyway, Mullahs, the last thing I wanted to mention is the manual itself, where they have said, Mullahs, that any doubt regarding issue of registration of any person applying for registration or considering any such objection against a person already enrolled in the electoral roll, he should refer the case to the Union Government Ministry of Home Affairs to determine the issue under the Citizenship Act. That's their own manual. So, Mullahs, they can't remove me from the roll. I'm deeply obliged to your lordship.
May I please, Mullahs? I'll just keep it very short. There's a short note of 4 pages which covers essentially 4 points. Yes. Excuse me, can you just send it up?
Which page of the manual, Mr. Sibbal?
Sorry?
Which page of the manual?
Oh, which page of the manual? I just give it to you. I just give it to you. Volume 4A, page 188. Chapter 7, volume 4A, page 188. May I be excused, Mullahs?
Yes, Mr. Gopal. Thank you, Mr. Subba.
Mullahs, just briefly.
We are dividing up our submissions. He will just argue the legality of the SIR, Lord, and I will argue on the procedures for ADR.
On the legal aspect,
the only request is that whatever has been argued, there is no need.
Yes, yes.
Of
course.
absolutely, which is why I think a couple of points were covered by Mr. Sibbal, so I'm not going to touch that again. I'll just briefly tell your lordships. Lords, I just want to make it clear that the issue before the court should not be obfuscated by the submissions that have come before. Clearly, what we are saying is this. Once you are on an electoral roll, because we are individuals also in our ADR petition who are people who are on the electoral roll. Once you are on the electoral roll, certain rights accrue to you. can those rights, which are valuable civil rights, can those rights be in any way taken away because the existence on the electoral roll carries with it, one, your right to vote, which is very, very critical and crucial in a democracy. But the second and most important thing at a very practical level is that passports are available to all Indian citizens, whether they are adult or minor, they are available. Our ECI cards, our voter cards, the EPICs as they're called, is the only evidence of citizenship that adult Indians have in the largest degree of coverage. There are these two documents. The passports have about a 5 to 7% coverage, but that will include children as well. But 90% or 93% of our country relies heavily, and these are not people who are here, my lords. There are people who are not well heeled, who are in the villages, in the boondocks. For them, they clutch on to this fact that they or their parents were on electoral rolls. That's why electoral rolls carry a very, very important place for them, because they can exercise their civil rights as citizens. And these are very, very core rights. Article 19 rights are rights which they can't exercise if they're not citizens. There were other rights, statutory rights as well, which I'm grateful that Mr. Hansaria mentioned, but those are the rights which are available to them. The problem is on the ground when evidential documentation is sought for. If you can't show one of these two, then they live in dread. They live in dread of being treated as foreigners and being thrown out of this country, because God knows when that axe will come and fall. We are seeing ICE do that in the United States. It may happen here. So you clutch onto that document. It may not be this present dispensation or this government or this election commission that we're worried about. We're worried about the fact that that small piece of paper holds protection for you and for your civil rights and your right to be a part of this country, which they so grossly require. Now, keeping that in mind and keeping in mind the fact that the SIR today, what it does, at least for Bihar, they created a cutoff date in 2003 and said that those after that will have the onus shifted on to them to prove all those aspects which are required for registration all over again. That is the second major problem with this, that an onus has been shifted because these people are already on the electoral roll, and they'd already participated in at least 5 elections and voted in 5 elections. Today, they find themselves having the cost turned against them and told that you have to prove that you are in fact citizens. Now, Article 326, Mr. Sibal has taken you through. Article 327, I just wanted your lordship, if you'll take the note, the third paragraph in that, if you'll take it for a minute. The electoral rolls in para 2, reading 326, I'll just read paragraph 2. 326 provides for the entitlement to be registered as a voter. That's the words used in 326. To one who is an adult citizen who has not attracted the 4 disqualifications listed there. There can't be any other disqualifications except those 4. Article 327 allows Parliament to make law for preparation of electoral rolls subject to the provisions of this Constitution. And that, my lords, in Anup Paranwal, in para 178.3, the Constitution bench, has been read to be subject to Article 326. So when they are preparing it in 327, it has to be subject to 326. So keeping that in mind, if your lordships now sees that the 2 Representation of People's Act 50 and 51 has to be read in light of 326 and 327, with 327 being subject to 326. The scheme of the acts, the 2 acts, and Mr. Dwivedi touched upon this as well. The 1950 Act is dealing largely with delimitation of constituencies and with electoral rolls and lays the procedure down for it. I'll come to the interpretation of section 21, which is critical. But the 1951 Act deals with everything else, including disqualifications, qualifications, etc., not only for standing, but also for being a voter. Section 11 and 11A, please take note of that, because those were provisions which were earlier deleted and modified and brought back, deals with what are the disqualifications from being a voter. So when Mr. Dwivedi says that the 1950 Act is a complete code on its own and it takes care of everything dealing with electoral rolls, not so. The 1950 Act compulsorily needs to look at the 1951 Act to see whether a voter is disqualified. Because if a voter is disqualified, that man will have to then ensure that an inquiry is conducted under the 1950 Act and the correction or deletion takes place under the rolls. So these form a fabric, these two acts together. The reason I say this is in section 62, because we have read it before, if I can just read that for a minute, of the 1951 Act, the phrase used is no person who is not and except as expressly provided by this Act. That's the 1951 Act. Every person who is for the time being entered in the electoral roll of any constituency shall be entitled to vote in that constituency. I am that person. I am already entitled because I am in the electoral roll for that constituency. And the only way you could have taken that right away from me was under the 1951 Act. I hope I'm making myself clear. It says no person who is not and except as expressly provided by this Act, not the 1950 Act, you knew it existed, under this Act. There's nothing in the 1951 Act that permits them to undertake an exercise which will take away my entitlement under the law. This SIR exercise stands on a weak legal footing for the following 4 reasons. The first, and Mr. Dwivedi was kind enough to admit, that when Anup Baranwal's constitution bench says the right to vote is a constitutional right, he said, I have no cavil with that. He said that in his oral argument, saying, I'm not disputing that. If you are not disputing that as the Election Commission, then a constitutional right which is available to a person who is already on the rolls has been taken away without amending the Constitution, without amending the 1950 Act or the 1951 Act, without bringing in any rules, without issuing any of the orders which are apparently available to you under Article 324. So far, it's only the symbols order which was issued by them in the 60s under that plenary power. But you didn't adopt A, B, C or D. What did you do? You issued an office order in July last year and told us that you're going to undertake this exercise for the entire country. And that brings me to my interpretation of section 21. It can't be both ways because their argument is that I have plenary powers under 324. If they have plenary powers under 324, why bother interpreting section 21? I ask myself this because according to you, it's plenary powers. I don't need section 21 for this. And then they jump across and say, no, we rely on section 21. And I think Justice Bagchi put very appropriate question to the Election Commission when they were arguing that interpretation of section 21 about Mr. Dwivedi, why are you going to section 21(2) and trying to interpret the first few words of that? I hope your lordships remember this was day before yesterday. And this was mystifying us as well because the clear argument available to them is 21(3) because 21(3) allows them to depart from the rules, the prescription, so they can go do everything under 21(3). When we revisit and we look closely at the scheme of the Act, and if your lordships will see for your lordship's assistance, I have put this in page 3 at the bottom of my note about the interpretation, which I believe is the correct interpretation of 21. And let's start with 21(3) for a minute, my lords, of the 1950 Act. Notwithstanding anything contained in subsection 2, that's only subsection 2, not subsection 1, the Election Commission may at any time, for reasons to be recorded, direct a special revision of the electoral roll for, please mark this, any constituency or part of a constituency in such manner as it may think. Constituency for this part of this Act is defined. And your lordships may go back to section 14 and says constituency means an assembly constituency, 14A. Now, when constituency is defined and they're conscious of the fact that when you have to drop the basic electoral roll for the entire constituency in the beginning, that I think all of us are ad idem that is the interpretation of 21(1). 21(2), and this is what I just wanted to acknowledge the assistance that I had from Ms. Neha Rathi. She directed me to what I believe is the correct interpretation of 21(2). If your lordship will see, it says the said electoral roll, A, shall, unless otherwise directed by the Election Commission for reasons to be recorded, be revised in the prescribed manner by reference to the qualifying date before each of these elections. Right, Manoj? Now, the emphasis that they placed on unless otherwise directed by the Election Commission is for them to argue that we can depart from the prescription and we can go ahead and have something like the SIR under these words. This was their argument. Now, the correct interpretation has nothing to do with that. The correct interpretation only this, that because A mandates that the Election Commission shall conduct these revisions before every election, shall, unless otherwise directed, allows the Election Commission to step aside from that mandate and not conduct a revision as mandated here. I hope I make it clear. A mandates them to make the revision. Like your lordships remembers in that Assam case, the argument was, let's rely on the new roles, they haven't carried out the revision. The first few words, and this escaped the attention of that Indrajit Barua judgment, unless otherwise directed by the Election Commission for reasons to be recorded in writing, be revised in the prescribed manner. So that means if you want to do it at any other point of time, that will fall under B. But if you don't want to do it, if the Election Commission says, I can't do it as per this mandate, they have to give reasons. That's all it is. So A goes against a mandate. B is a license for them to do it at any other point of time. Therefore, when you come to 3, and your lordship may note 1 and 2 are dealing with constituencies. 3 is very narrow. 3 allows them to escape a prescription which flows from a statute, which flows from 324 to 327, and says, notwithstanding anything contained in 2, only in 2, the EC may at any time for reasons to be recorded, any time for reasons to be recorded, direct a special revision for any constituency or part of a constituency. Mr. Dwivedi was wise. He knew that this provision can't come to the rescue of the Election Commission to conduct one for the entire country for all constituencies. Which is why the best argument that they have within the framework of the law is to possibly misinterpret 21 subsection 2. Just come to page 2 for a minute of that note, Manoj.
Page 2 of your note.
Of my note. Para 6.
Yeah.
Referring to how the enumeration forms have taken away all these rights. Para 6. It is precisely for this reason that the 3-judge bench in Lal Babu Hussain noted the following. The factual similarities is what I wanted to draw attention to. Para 8 noted that only 4 documents were permitted to be relied upon. Para 9, no inquiries were conducted. Para 12, notices were sweeping, covering the entire populace without individual inquiries. And para 13, enumerators were appointed, time was short, and no other documentary proof was entertained. On all 4s applies to this case. All these 4 factors existed, which is why they held at 6 and 13 that there is a presumption in favor of those already on the rolls, and removal can only be by following the procedure laid down. And paras 13, 2 to 5, the directions were that individual inquiries of those suspected to be conducted based on evidence and documentation with a hearing. 2 last points. Para 7, please note that Indrajit Barua Malaj we have been referring to is an order. We have placed that on record. It's our fault, all of us as lawyers. We should have shown you, which we discovered only later, that there was a detailed judgment later with reasons in Indrajit Barua, which the court passed. I'm handing up copies of that. One of the important aspects of that is that in paragraph 13 of the detailed judgment, because they say we had passed a summary order, they do elude and largely it remains the same. But one of the factors there in para 13 of this judgment, Manoj, if I can just trouble you to just see para 13. Page 733. The middle of para of page 733, middle of para 13, after the first extract, it says, if I can read that, we indicated in our order of September 28, 1984, that the statement made on behalf of the, I'm sorry, my lords have that?
Yes, we indicated.
The para 13, that the statement made on behalf of the Election Commission must allay the apprehension of all the petitioners in the case, since it is made clear that before elections are held in Assam, there would be revision of the electoral rolls in the manner indicated in the statement. Considerable argument was advanced with reference to the electoral card. As it appears, the Election Commission had introduced a form different from the one prescribed in Form 4, which is what we are saying here. Read with Rule 8 of the Electors Registration Rules. Here again, a statement was made on behalf of the Commission. So the Commission has made a statement before this court. For the sake of greater clarity and keeping in view the provisions of Section 2E of the Representation of People Act, which defines elector, my lords, and Form 4 of the Electors Rules, the word citizen shall be substituted for the word elector wherever it occurs in the electoral card by issuance of a direction by the Election Commission. With the adoption of the basis indicated in the statement, the objection on that score must be taken to have vanished. So at that time, the Election Commission was willing to make, I think, fair concessions because they understood how they were skating on the brink of illegality. Today, I think we see a very different stand being taken by the Election Commission. I will finally come in my note, my lords, para 9, if your lordship sees, the powers which are exercised, my lords, para 9, that this 21.3 they believe is a catch-all provision for everything. Sections 22 and 23 are very specific of the Act. 22 deals with corrections and 23 deals with inclusions. In both instances, even when it's a death, in both instances, individual inquiries are called upon, which is why in 24, when they talk about appeals, the appeals are only under orders of 22 and 23. There is no other appeal available. So today, for example, if an SR is conducted without reference to these, there's nowhere to go. Even those logistical issues that they were having, where names are misspelled, etc., those are not available under the statutory scheme. So the danger of us, according to the Election Commission, powers greater than what the Constitution gives them is something that one must keep in mind. When a person's citizenship or lack of it is suspected and that person is on the roll, the person objecting must come with evidence of the fact that that individual has taken some other citizenship, or that person had possibly committed a fraud when the initial registration took place. When that evidence is brought, it is only then that the Election Commission will act as an adjudicator, not about citizenship. I hope I'm making myself clear. Not about citizenship, but about the fact that you today are not a citizen for the purposes of Section 19 of the Act. 16 is conditions for registration. 19 is a condition while you are registered. You have to maintain that throughout. Being a citizen, you have to maintain until you cease to be. Finally, my lords, there were many attacks, and because we are appearing for ADR, I'm saying this, by the Petitioners' Council on ADR specifically. And I think because we have been here and we have seen the kind of human work that ADR has done, possibly I believe that the concurring judgment that they're relying on of Justice Datta's in the EVM matter, where I also had occasion to assist the court, I think that perhaps may have been misdirected. It came 2 months after the Constitution Bench in electoral bonds held in ADR's petition. ADR's petitions in these courts, there have been more than 20, have led to the nota registration. ADR petition led to every candidate giving their criminal background, giving affidavits of assets as a separate column. So ADR for 20 years has done what the Election Commission has not done in exercise of their so-called plenary powers. If they had issued orders for all this, ADR would not have to come and get orders. So I don't think this attack which repeatedly goes on ADR, which even the presiding judge in that bench did not agree with, I don't think that should at all be pressed into service. I'm most grateful. I believe this is a completely illegal exercise. Should never have been embarked on.
Lord, I just wish to argue in rejoinder a little about the procedures. But Lord, before I take 20 minutes of your Lordship's time, can I request Mr. Yogendra Yadav to take 10 minutes of your Lordship's time, just 10 minutes, to give your Lordship a broad picture of what has happened as a result of
that 10 minutes from your time, Mr. Bhushan.
Pardon, Lord?
That 10 minutes we don't mind, but we will deduct from your time.
Your Lordship may give me only 15 minutes, but just give him 10 minutes. I'll take only 15 minutes. Acha, let me, my Lord, quickly finish my, then thereafter, or first your Lordship may just hear from him. It may be
whatever that you
10 minutes he will take, then I'll just take 15 minutes.
All right.
Take only 5 minutes.
Take it, all right, come.
दोनों का इधर ही आ रही
Grateful, my lord. This is just a very short summary of the rejoinder. Grateful for the opportunity to be heard. I'm also grateful to the Election Commission that so far they have not disputed a single fact that I have had the honor of bringing to the court's attention. Not one single fact, source or method they have questioned, with a minor exception which I'll just come to. In the presence of all these legal luminaries on both sides, I do not presume to speak on law. I'll limit myself to just facts, because as your lordship had observed, we do not operate in a vacuum. There are larger things that are happening. My point is in two parts. One is a response to Election Commission's response on the facts, because they have responded to some of the things I brought to their attention. Second part is responding to the one thing Election Commission brings up again and again, which is no appeals in Bihar. So in these two parts, I would respond. If your lordship remembers, right in the beginning, the first day I had the occasion to address you, I had said there are three things that we must judge SIR against: completeness, equity, and accuracy. These are three global standards of any electoral rolls. On completeness, my argument was that SIR has resulted in a sharp decline in electoral population ratio, which I had demonstrated in Bihar, indicating that there is a structural design defect. That's a point I've made again and again. It's not accidental. There's a design defect. The problem is not in doing any revision, which must happen, but the kind of revision that's happening. I remember having said, wherever in the world you take this design, it would lead to disenfranchisement. The Election Commission's response is number one, and that's the only thing they have ever disputed. They say that I've been relying on population projections of 2019, not of 2020. They are absolutely right. There was a subsequent projection of 2020, but I think Election Commission forgot to mention that both these projections are identical down to decimal points. I don't see what's the point of mentioning that. The Commission also says that these are mere estimates. Of course, these are estimates. And they quote the committee. The committee says, yes, slight omissions or duplications are possible in our estimate. I agree. But, my lord, slight duplication cannot be 80 lakh people. Slight duplication. And then, incidentally, the errors that happen in the census estimates are errors about birth rate. In this case, we are not dealing with birth rate because everyone that we are speaking about was on census in 2011. So no estimate of birth rate is required. It's only death that we are looking at. Unlikely to make mistakes. And number three, my lord, they say Bihar's EP ratio had exceeded 100 in 2022, something that your lordship had observed, which is absolutely correct. And in fact, that's precisely why I had brought it to court's attention. But the very same graphic shows that it had already come down. The normal process of annual revision had already brought it down from 106 to 97. So the disease was cured before the medicine was given. There is absolutely no connection between the two. May I just draw your lordship's attention to the one graphic that you have, this green one. We are speaking of Bihar, my lord, but Bihar is done. I just wanted to demonstrate to you about the design defect. Every single state where SIR has gone, the voters proportion has fallen substantially below the population ratio. It's not an accident. Your lordship is absolutely right about migration. But my lord, Bihar is out migration state, everyone knows it. UP is out migration state, everyone knows it. According to the Niti Aayog of Government of India, Tamil Nadu and Gujarat are in migration states. So someone can say Bihar and UP are losing people. Why is Tamil Nadu losing 97 lakh? Why is Gujarat losing 74 lakh? It has nothing to do with migration, my lord. It is straightforward a case of a design. It is not a system.
It may be a case of duplication because these are receptor states. Gujarat, Tamil Nadu are receptor states of migration.
Yes.
So it is possible that these people may have been registered both in the rolls of Tamil Nadu as well as, let us say, in the rolls of Bihar.
That's the whole point, my lord, of referring to the population ratio. We don't have to debate these things. We do know the adult population of these states. Now, one state can go down. Experts can make mistake in estimating migration. Unless the whole of the country is migrating to the USA, all the states cannot lose. And that's the point I'm making. Every single state is losing. There is not one exception. The only exception I should point out is Assam, where SIR was not done. And in terms of ratio, we can see, because your lordship had interest in ratio being more than 100, yes, Tamil Nadu had more than 100. And Tamil Nadu has come down. But in every other case, it was less than 100 and has gone down further. The second point that I had made was about equity. The point was about gender, which is to say, and I remember saying, wherever you take SIR, women will be thrown out of the voters list disproportionately. And my lord, this is exactly what has happened. The Election Commission's response is, look at last 30 years of data. I'm willing to look at last 100 years of data. But my simple point is, before SIR, you were this, after SIR, you're down. And my lord, if I can again bring your attention to this little graphic, this is exactly what has happened in every single state after Bihar. Election Commission owes an explanation to this country. Why is it that in every single state you go, you take this instrument called SIR, and in every state the gender ratio falls? And by that estimate, may I suggest that 60 lakh women have been additionally thrown out so far. Additionally, SIR is throwing people out. You can say legitimate, illegitimate. About 6 crore people have already been excluded so far, which include men and women. But the disproportionate exclusion of women because of the design defect is 60 lakh. This is shocking, my lord. I had made the point about Muslims being disproportionately excluded. The Election Commission's response is very fancy language. Communal approach which needs to be deprecated. Thank you very much. You must deprecate the Election Commission itself, because in 2001, this is exactly the language used by the Election Commission. I have annexed that document. Election Commission, in the only known instance of use of 21(3), is in Nathdwara in Uttar Pradesh in 2001. To my mind, that was the only known case of use of this. Thakurdwara. Election Commission's language of that order is voters of one particular 15,800 voters of one particular community have been excluded. This is unacceptable. Therefore, we are ordering. So if looking at a community, and that community incidentally were Muslims then as well. If looking at community is deprecatory, I'm afraid Election Commission will have to deprecate a lot of its own records. My third point, my lord, was about accuracy. Now on accuracy, I'm not arguing that SIR has led to loss of accuracy. We do not know that yet. That we will get to know only much later. The only point I had made was that it does not seem to have improved accuracy, because I had brought all kinds of things to your attention. We had a good laugh about it. Bihar having voter list in Tamil and in Kannada. My lord, the only thing I want to bring to your attention, and this is shocking. I brought this to the court's attention on the 9th of October. You said, yes, they will correct it. 17th of October, almost 10 days later, the final voter list which went to the polling day was finalized. And my lord, I have shown that exactly Tamil language, Kannada language, even those handful of gross and silly, ridiculous errors that I had brought to the attention of this highest court of the country, they did not change even those 10 or 15 mistakes. Nothing was changed. This shows the respect that they have for the Election Commission of India. And all this, incidentally, I'm not bringing anything new to the attention. Whatever I'm saying, my lord, is in my affidavit dated 3rd of November, which is on record. And the commission does not even seem to have read that affidavit. I must be very bad with statistics. The last point is about the Election Commission's own claim. Repeated claim everywhere in the country. There wasn't any appeal. Now, that's not statistics. It's a play with English language. Actually, there are 3 different claims that the commission is making, which they have made at different points of time. The first claim Election Commission says is, no aggrieved individual approached this honorable court alleging non-inclusion due to lack of documents. It's an umbrella claim. No appeal is an umbrella claim, which includes 3 different claims. Yes, they are right. No individual approached this honorable court alleging non-inclusion due to lack of documents, because if he did, he would have been a fool. Because by then, your lordship had ordered Aadhaar card acceptance as a 12th document. After that, the business of document became redundant. Why would anyone come to you for that? Why would anyone go there? You had sorted the problem. Obviously, there was no one appealing on that. That's part 1. Part 2 is they say that there were no appeal. And that's the no appeal part actually applies only to that tiny fragment that once draft list was released, after that, 3.66 lakh voters were deleted. In Election Commission's language, that's the only deletion because they do not recognize the remaining 65 lakh as deletion at all. So 3.66 lakh, there was no appeal. They're right. There was no formal appeal, certainly. But that 3.66 lakh cannot be used to say there was no appeal on the 69 lakh deletions. That's one. And number 2, my lord, what happened on the ground, and Mr. Kapil Sibal hinted at that, what happened on the ground was this. There were large number of unjustified exclusions in this 3.66 lakhs. Whoever approached the election authorities was told, kar denge tumhara, and they indeed were done. I must thank the Election Commission. They actually incorporated those names. But the simple condition was, तुम्हें अपील करनी है कि नाम शामिल करवाना तय कर लो. Everyone wants मेरा नाम डाल दो जी, मेरे को क्या चाहिए? So large number of names were included. They were wrongly excluded. They were included even in 3.66, but no formal appeal happened because that avenue was blocked. And the final thing, my lord, is on the 65 lakhs. Were there no appeals? Not at all. Election Commission's own documents admit it. In that 65 lakh, my lord, Election Commission says we had 36. I'll give you the exact figure. According to the Election Commission, there were 36,475 claims for inclusion. These are people who were part of that 65 lakh, but who said my name has been wrongly excluded, please include me, 36,000. But that is not a correct figure. It is not a correct figure because Election Commission to this date does not have any mechanism for finding out when someone is applying from Form 6. How does the Election Commission know that this is a new person or is it an excluded person who's coming back? There is absolutely nothing in their procedure which says so. So I'm surprised that they think the figure is 36,000. What we did, my lord, because the Election Commission wouldn't give us those figures, so we ran on a computer program these 65 lakh names. And we said how many of these names are found in the final rolls by whichever mechanism. And we found 2,97,921 names which were in that list of 65 lakh excluded, which were on the final rolls of Bihar. How do they come? Very simply, the man goes to his BLO, मेरा नाम नहीं है. BLO says, ये form भर दो. So this 65-year-old man says, I'm the first time voter. He fills his form. How do we know this happened? Because of Election Commission's own data. Election Commission tells us that 21.53 lakh new voters were included because they had crossed the age of 18. That's their official description in the document they've just submitted 3 days ago. So 21.53 lakh people were included because they have crossed the age of 18. They have become eligible. My lord, how many of them are of the age of 18 or 19? According to Election Commission, only 19.5%. Only 20% of these 21 lakh people are of an age where they should have used Form 6 to be a new voter. 80% were outside that. Now, I'm not saying all those 80% were excluded voters who were trying to come back, because normally some little things happen. But I'm suggesting that the idea that there were no